Good morning, everybody. Happy Thursday. Welcome to the Courtroom Files Live. Let's start our day with Judge Simpson. He's doing his probable cause conference docket.
Geez, sorry, thank you.
Court does call the case of the People versus Anthony Lafredo.
Good morning, Your Honor. Karma Dadush on behalf of Mr. Lafredo. Mr. Lafredo, can you please state your name for the record?
Anthony James Lafredo.
Thank you, sir.
Your Honor, we are going to be binding this case over to circuit court. There is an offer on the record, and we would like to, an offer in circuit court.
Doing what?
We would like to please have this bound over to circuit court. Waiving preliminary examination.
Told you that. Cannon?
No, it was just
Daddy?
me. I don't know why I always
Mr.
have
Daddy?
problems with preliminary
I didn't know who
examination.
you were parodying. But go ahead.
Parodying myself, my own brain. Sorry about that. This is not even the end of it. The end of the issues. Mr. Lafredo is in.
Why do I have to start with you?
You started with Yagi, and
I know, and that was quick. This is not.
This will
Go
not
ahead.
be quick, unfortunately. Mr. Lafredo is in Jackson County Jail. I have not been approved yet, even though I submitted that pretty early, to talk to him to be able to get his signature for the preliminary examination waiver. Do we need to adjourn, or am I able to ask him if I can sign on his behalf on the record?
Mr. Lafredo, you're waiving your right to a preliminary examination.
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do understand.
All right. You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes, Your Honor, I do.
All right. People also waive the right.
We do, Your Honor.
You can just, she can affix your signature to the form, sir.
Absolutely. Thank you.
And for the record, Ms. Pirani met with him a couple of days before. So it's not like someone, another APD met with him regarding this case and went over all of this with him. So this is not, just because I didn't meet with him this week doesn't mean he doesn't understand what is happening today, because we discussed that with him earlier. I just want to put that on the record.
That is correct.
Understand?
He does, yeah. Thank you, Mr. Lafredo.
Is there anything else?
Nothing further.
All right.
Thank you.
Preliminary examination having been waived. Defendant is bound over to circuit court on the single count.
Thank you, Your Honor.
Thank you. You guys have a good rest of your day.
Hold on.
Oh.
Now you don't want to talk. Your turn.
We were formal reading of the charges in Samuel.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
September 3rd at 1:30 with Judge Conlon.
September 3rd, 2025, 1:30, Judge Conlon. Bond in this matter will continue. Thank you, Mr. Lafredo.
Thank
Your
you.
Honor. Thank you, Mr. Lafredo.
Court does call the case of the People versus Brandon Kelly.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Kelly. Mr. Kelly, please state your name for the record.
Brandon Isaac Kelly.
Thank you.
Your Honor, today we are asking for an adjournment to continue a plea discussion and allow me to do an AIM referral. I am also asking to address bond.
Probable cause conference will be adjourned July 22nd, 2025. 9 a.m. bond.
Thank you, Your Honor. Regarding bond, his bond is currently a 5,010%. We're asking you to consider a personal bond. Mr. Kelly does stay in Washtenaw County. He has an Ann Arbor mailing address. He reports that prior to being in custody, he was engaged in community service. He does not have a criminal history. He understands the bond conditions not to go back to target or have contact with the complaining witness. He does have another case open, but it is my understanding, based on the record on JIS, that $100 bond will turn into a personal bond upon his release on this case.
So he's held on another matter.
But if this were turned into a personal bond, that would automatically turn into a personal bond.
Is that the way the bond reads?
On GIS, it does state that Magistrate Garwood said it that way.
People believe that the bond term that is very fair and appropriate in other cases that Mr. Jones, other unprovoked, most of the cases that has consist of him being in public places and just punching people in the face, either because they looked at him or he looked at them. In this particular case, he had the use of the watch as a makeshift brass knuckles, which escalated into a felony. These cases happened within about 3 weeks of each other in the month of June. I'm not really sure what's going on with Mr. Kelly, but I'm concerned that it's not the most stable at this point. And I would request that.
So was he on bond on the other case when this happened? Not yet. All right, anything else?
No, thank you. Oh,
Court
sorry.
does believe that the bond is set appropriately. Motion for bond reduction is denied. Bond will continue. Thank you. Court does call the case of the people versus Benjamin Hoffman.
Ally Zend on behalf of the people, Your Honor. Here, maybe in the hall, I'll go grab them.
Okay, so the people versus Sean Bilodeau.
Good morning, Your Honor. Edward Dugas on behalf of the defendant.
Sean Bilodeau?
Your Honor, there's an outstanding DVD I need to obtain. I'm asking for just a brief adjournment.
Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Great. Where are they? Okay, court does call the case people versus Jacqueline Jones, Washington, all three cases.
Mackey on behalf of Mrs. Washington, Jones Washington. Mackey requesting permission to practice under Michigan Court Rule 8.120 under Public Defender Brian Bowling.
Permission to practice is granted.
Thank you, Your Honor. Appearing on behalf of Jones Washington, she's in custody.
Yes.
Oh, she's on Zoom.
Could you state your name, please?
Jacqueline Jones Washington.
Thank you.
We are still waiting for a competency report in this matter, Your Honor, so we respectfully request an adjournment.
I have one that is
So I saw in
dated
JI.
June 17th. You have that one as well?
Our office hasn't had one since May.
Got it.
So this is the report on the 2025 case, so she needs a high one.
Got it. Okay. My staff just reminded me, this was the case where she had been, I think, found incompetent but restorable on two of the matters. We needed a new order for the third case, the 2025 case. This report that just came through, which has the same finding of incompetent but restorable, is the same as the other one. Does that make sense to you? I recall having to do this. We just didn't have an order for the 2025 case.
Okay, so did you need that order? It was sent last time, I believe, right?
Well, we didn't have the order for the forensic exam. So we did that.
Yeah.
this is the report that this current report, which is effectively the same as the other reports, is coming from that new order that we set for the
Okay.
request for the preliminary examination. Miss McNally, was there something you were going to add?
Absolutely. I'm just taking notes, Judge. I just wanted to make sure I was catching.
What do you mean you're just taking notes? Just gonna.
As far as people go, we stipulate to the findings of the report that Ms. Jones Washington is.
If you, okay, and I don't know if you're in a position to stipulate to it. It's the same, it's the same finding, but I don't know if you feel that you're gonna need to go through it with your client.
Can I have a 2-week adjournment so I can review that report with my client? Okay.
I'll adjourn all of these matters. I'll adjourn the competency to July 22nd. Well, we're not gonna be able to get it back because that's not 2 weeks. It's gonna have to be July 31st, 2025, 9 a.m. Bond on all of these matters will continue.
Thank you, Judge.
What is that date again? If you can please repeat that.
It's July 31st,
And
9 a.m.
9 a.m. Thank you so much.
All right, got it?
Yeah, thank you.
Thank you. Court does call the case of the people versus Rio Boyd.
So, Mrs.
And then on behalf of the people, Your Honor.
Particular on behalf of Ms. Boyd, would you state your name for the record? Oh, sorry about that.
Riel Boyd.
Judge, I was just appointed, I think yesterday, may we get a short adjournment?
Probable cause conference will be adjourned July 22nd, 2020. 9 a.m. Found continued.
July 22nd. Thank you,
That's
Judge.
Tuesday. Thank you.
Thank you.
Okay, court does call the case of the people versus Duran Wilburn.
Alexander on behalf of the people, Your Honor.
Edward Lucas on behalf of Jerome will be approaching.
And good morning, Miss Lowe. Just because you think that you're a small walking past, I could still see. Your name, sir?
Ron Wilburn.
Thank you.
Your Honor, at this time, discovery is complete to my knowledge. I'm asking for a preliminary examination.
Okay. 20 seconds. Would the people have their witnesses available the 22nd?
We'll do our best, Your Honor. And I did want to make clear aware as well, we did request a 911 call on the 9th, so it should be here before exam.
All right. Preliminary examination in person, July 22nd, 2025, 9 a.m. That is before
Judge Barr.
Judge Barr. Bond will continue.
Thank you.
Thank you. Court calls the case people versus Dacia Moore.
I'm here. Good morning, Your Honor. Christina Costantino appearing on behalf of Ms. Moore. Ms. Moore, can you please unmute and state your name for the court? Deja Moore.
Thank you, ma'am. Constantino, you just don't come to like Washtenaw County anymore?
Judge, I love Washtenaw County. I would much rather be there with you than where I've been. Trust me on that one.
Okay. All right. Well, everybody else misses you. I don't. All right. What are we doing? What are we doing?
I'm sorry about that, guys. I hit a button. Back to Judge.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Right. Thank you. Does call the case of the people versus Isaiah Bozeman.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bozeman. You state your name.
Isaiah Bozeman.
What are we doing?
We're requesting an adjournment to review discovery.
Are you, it's not signed, but are you aware of a character reference letter sent on his behalf?
I don't have that, Your Honor, no.
All right, I'll make sure because since it came to the court. Yeah. That come with it.
Some cases somewhere.
I don't know why they're here. There's a number of them sent for whatever reason. There's not going to have an influence on the court, but we'll provide those to both parties.
Thank you, Your Honor.
All right. You're asking for an adjournment of this matter. I'll adjourn this matter. Probable cause conference to July 22nd, 2025, 9 a.m. Bond continued.
Adjourn.
Court calls the case of the people versus Heather Booth.
People.
It's rushing.
Oh, correct.
Good morning, Your Honor. Sydney Rushing, appearing on behalf of Miss Booth. Is that Miss Booth in the Wayne County Jail by chance? That's where she is currently located, Judge.
Do you have her?
We did not know she was in custody.
We did not know. So I'll have to kick this out to the 31st. So we have the 2 weeks for a writ if she's going to be there.
Your Honor, she's on remand status, so it's my understanding that she's likely going to remain there till then.
Okay. Probable cause conference July 31st, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court does call the case of the people versus David Mariquin. 2 cases.
Your Honor, Alex Warren Green on behalf of Mr. Mariquin. You state your name?
David Mariquin.
Your Honor, at this time, we're asking the court to set both matters for preliminary.
All discovery is complete.
Discovery is complete, Your Honor.
People have their witnesses available the 22nd. Preliminary examination in person in these matters will be set for July 22nd, 2025, 9 a.m. 9 or noon?
It's actually at 12.
12 noon
With you.
for me. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Todd Amerman.
I'm Lori Yaki, Assistant Public Defender with and on behalf of Mr. Amerman, who is standing to my right.
Your name, sir?
Todd Ammerman.
Your Honor, I do apologize. I will 100% take responsibility. We do have a plea form. I know I should have submitted it yesterday. Mr. Amerman was very diligent in calling my office, and we were only able to connect after. But we have agreed upon a plea. It's not a no contest. It's just a guilty plea to an added count 2 abuse. So I'm hoping the court will take this today.
Plea form indicates that the defendant will be pleading, that box was a check. He's pleading guilty.
Yes, I apologize.
That's what happens when we rush things at the last minute. The plea form indicates that he's going to be pleading guilty to the charge of use of methamphetamine. On his successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement.
Yes, Your Honor.
Let's have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Todd L. Hammerman.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Do you understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in 14A4 District Court.
Yes, sir.
Understanding all of that, do you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
Has he signed an advice of rights form?
I,
You're not ready. I'm passing it.
okay, I'm sorry.
Court calls the case, People versus Zavratko. Get enough, I think.
Good morning, Your Honor.
Good morning, Your Honor. Roba Hamden requesting permission to practice pursuant MCR 8.120 under the supervision of Assistant Public Defender David Ballinger.
Permission practice is granted.
Thank you. I am here on behalf of the Gravko Kitnell. Can you please state your name for the record?
Sure, good enough.
We are requesting a 2-week adjournment on this matter for negotiation.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Thursday. Let's change it up a little bit. I gave you a preview of it accidentally a minute or two ago, but let's go to Judge Boyd and say good morning to her.
Hello.
How you doing?
I'm doing okay. How are you doing?
May I ask who our colleague is that passed away?
Jocelyn Andrews.
An attorney?
Yeah. She was an attorney and a nurse.
Oh.
Yeah. All right, everyone, please whisper and remember my previous rules. Do not approach until you've spoken with your client and conferred with the state. Court is calling 2025 CR 004949, 2025 CR 004950, State versus Jarrett Michael Wade. Can I have parties announced?
Duffy Whitlock for the state of Texas, Your Honor.
James Seelock for the defense.
And are you Mr. Wade?
Yes, ma'am.
All right, you entered a plea of no contest on June 26th. This defense waived PSI, and this was to give the defense a chance to bring witnesses if the defense wanted to bring witnesses. Did you have any witnesses?
Well, it was my stepfather, but he had emergency back surgery yesterday.
Okay.
So he couldn't come. He's a ex-police officer.
Okay.
Yeah.
All right, so what was he going to say?
He was basically going,
Say, give you probation, right?
I'm good character, he's a hard worker.
All right, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Gerard Willie.
All right, are you currently employed?
Yes, ma'am.
What do you do?
UPS driver, part-time.
How long have you been doing that?
4 years.
You're not one of the people who throws packages over there.
He generally brings it to your door.
In a box, or I place them right there and get you going.
All right, do you have any children?
Yes, ma'am.
What are their ages?
12 years old.
All right, and do they stay with you? Do you have, all right.
He's married. He's been married for 15 years.
We've been together for 15 years.
See, together for 15, married for 7. All right,
Okay.
so here's the trick question. When's your anniversary?
November 3rd.
Ah, I
Good
like
man.
that. Usually people don't remember their anniversary date. Well, the state is opposed to your application for deferred adjudication, but they're recommending, let me see,
Probation.
they're recommending community supervision. So state, do you have any objection to the court giving him deferred adjudication?
No, Your Honor, the state's.
All right. So here's the thing about deferred adjudication. The offenses that you have, they're third-degree felonies. The agreement that you reached with the state was if you were ever revoked, the maximum I would be able to sentence you to is 10 years. With deferred adjudication, the maximum I'll be able to sentence you to 10 years is if you violate the terms of your probation. You understand? The thing about deferred adjudications don't show up as a conviction on your record, but they will still show up on your record. Do you understand? All right. And UPS, are they making you do drug tests?
No, ma'am. We don't, they do, like, deal with felonies with charges.
Okay.
Wishy-washy.
All right. So here's the thing. While you're on probation, you have to do drug tests. So you can either do drug tests where you actually go into the office, or either they can give you a patch. The thing about patches, it helps you with your time constraints. And I'm sorry, state, you may be excused. It helps you with the time constraints, but the patch costs more. Ms. Abrams, how much is a patch? A drug patch? Sure.
$50 every 2 weeks, Judge.
Every 2 weeks?
Yes, Judge.
Or you can do the UA. The UA will be once a month.
I'll take the UA.
All right.
Judge, also keep in mind we have that watch.
Ah, so they also have the watch. And how much is the watch? The watch is something new. It looks like a watch. You put it on and it's supposed to be less expensive.
I'm fine with the UAs.
Judge, I believe it's $5 a day.
Oh.
Okay. That $5 a day adds up.
Yes, ma'am.
Well, especially with the 12-year-old, right?
Well, same, yes.
All right. And cause number 2025 CR 004950.
49.
Oh, you have 2. Yes. All right. This is what the court is going to do. The court is going to sentence you to 6 years deferred adjudication. There's regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be 100 hours of community service restitution. I'm going to order parenting classes. Once those are completed, the community service hours will be deemed satisfied. This is to run concurrent with 2025 CR 004949. There's to be restitution, if any, to Stephen, that's with the V, Enriquez. The defensive driving course. No contact with Stephen Enriquez. Field visits 1 time per month for 3 months. Probation, is there anything else with regards to that cause number?
Your Honor, could I ask the court to reconsider the driving course? I don't know how that applies, and he is a driver with UPS.
Well, because he has an evading arrest. So that's why.
You understand?
And it'll help him.
Well, thank you very much.
You're welcome. All right, and cause number 2025 CR 004949. The court is going to sentence you to 6 years deferred adjudication. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting. Once that's completed, the community service hours will be deemed satisfied. This is the run concurrently with 2025 CR 004950. Again, restitution, if any, to Stephen Enriquez. The defensive driving course. Field visits 1 time per month for 3 months. Probation, is there anything else? All right, Ms. Ferguson.
Yes.
I need a 30-day reset for a restitution hearing.
Yes.
Do you need my presence for that?
Yes. All right, August 12th. Counsel and Mr. Wade, you can appear by Zoom. And let me see if I can find your trial court certification of defendant's rights to appeal. Is there anything else that you need from the court to be successful on this probation?
No, Your Honor.
No.
Can you give me
Are you gonna do his probation for us?
I thought I would. Isn't that part of my duties?
Yeah,
Or-
could be.
Okay.
All right, so Mr. Wade, do you need anything else to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because these are plea bargaining agreements, because I followed your plea bargaining agreements, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Right.
In this court, in order to be successful on probation, communication is key. If there's an issue, you need to let your probation officer know about it. If you feel as though they're not addressing it, you can come back to the court. We're off the record, if you're able to successfully complete everything, your attorney can talk to you about early termination.
Yes, ma'am.
All right, just have a seat. Probation is going to go over conditions with you.
I was gonna ask you, do we do probation talk now before
Yes.
the restitution? But you want me here
Yeah, or you can appear by Zoom.
by Zoom? Okay. And I'll get a notice with the Zoom numbers?
Oh, yes, and she's going to give him the reset form as well.
Okay.
Jordan Christopher Armstead.
Yes, Judge.
Hello.
Do you still have the plea paperwork in there from 2 weeks ago?
No, I do not.
Everything was,
Excuse me. Adriana.
Yes, ma'am.
They said there's some plea paperwork. Yes.
and Your Honor, a plea was taken. He was sworn in, a plea was taken, and we paused it, got off the record, and we came back 2 weeks.
Mhm.
But conferring with Megan Galloway, we're ready to go forward today with the plea.
With the plea?
Yes.
All right, once they pull the file, I will
All right.
take you up.
Yes, Judge. Did they say that? Okay. Okay.
Okay, guys, I asked in a poll if you wanted to do pardon parole hearings today. You said yes. Let's do one now.
Today's date is July the 10th, 2025. It's a Thursday. The time is 8:44. The committee on parole is seated here, and you can see who we are. I'm Steve Prater. Jerry Ledoux is to my right, and Chuck Tillis to my left. We're in Baton Rouge at the Department of headquarters for the Department of Corrections. Y'all introduce yourself in the room here in Baton Rouge. Okay, thank y'all for the work that y'all do. Okay, we'll first be going to St. Mary Law Enforcement Center and speaking to Daniel McNeil. Mr. McNeil, is that you I'm looking at on the screen?
Yes, sir.
Okay, and we're at St. Mary Law Enforcement Center. And who from St. Mary is in the room with you? Staff, would you introduce yourself?
Lieutenant Brian Benoit.
Okay, thank you, sir. Thank you for hosting us. Mr. McNeil, do you have a form in front of you that says about your hearing this morning?
Yes, sir, I do.
Okay, and did you sign that form and you understand it's a waiver and all the things that are on that?
Yes, sir.
Okay, all right. We appreciate that. Well, we're gonna go into these violations and you're accused when you get out of jail, as you know, you sign and say, I'll abide by certain conditions. And your parole officer says you didn't abide by some of those conditions. And so we're gonna talk about them, okay?
Yes, sir.
Okay, first off, there's number 2. Violation of 2, you were hard to find, is that correct?
No, sir, not really.
Not really.
I mean, in a physical, I ain't have transportation or nothing, but we was doing FaceTime. I was FaceTiming my parole officer.
Okay. You're saying not guilty? Okay, and you're saying not guilty?
Yes, sir.
You're saying not guilty, you didn't violate that? Okay, let's go to number 3. It says that you were released on 12/23 to GTPS Pro with a reported address of 450 Cottonwood. You confirmed the address at intake. Agents learned your actual address was 307 North Elm, and they made contact with you there. On 5/10/2024, after leaving the car at your mother's house, he made contact with you by phone, at which time you reported you moved to Morgan City. You were allowed a short time to look for work and report back to the parole officer, which you failed to do. On 11/18/2024, after again leaving the car at your mother's house, he made contact with you at phone, at which time you reported a different address in Morgan City. Okay. Tell me about that. Tell me what's going on.
Okay, I got out of jail and I was homeless. I had nowhere to go. My mom let me stay there for however time until I, find me a job, and it was going slow there. So, she said that she bought the house for her and her husband, and I was grown and I couldn't stay there no more. So I ain't had nowhere to go in Voss Parish because I never lived there. I always lived in Morgan City my whole life. So she said, well, what you want to do? I can take you back to Morgan City, or you're gonna have to get out here on the streets. And I say, well, my chances are better in Morgan City. Like, I mean, I know I've been there all my life. I had jobs there. I was supervisor at PMI. I could do better for myself in Morgan City. So she brought me back to Morgan City, dropped me at a hotel. She paid for the hotel for like 3 days, and after that, I was just on the streets. I mean, I FaceTimed my PO, I called him, I was letting him know what's going on, I let him know where I was. I had no reason to run from him. I just didn't have nowhere to live, and I was working, looking for work. I FaceTimed my PO, he told me it was okay, go ahead and look for work. I was sleeping on the back porch at my friend's house because he had daughters, and I couldn't, you don't know nobody around your daughters like that. So I really didn't have an address to give him, but I was trying. I was trying to, retain an address for myself so I could give to him. And the work just wasn't coming quick enough.
Okay.
And
all right. I think you've explained your side as well as you could. Have you ever been on parole before?
Oh, yes, sir.
Okay. So you know the importance of checking in. Have you ever revoked your parole before?
Yes, sir, one time.
Okay. All right. Let's move on to rule number 4. Okay. It says that on or about 1/24/2025, you were arrested by the Morgan City Police Department for the commission of resisting an officer and domestic abuse battery. You pled guilty to the charge of resisting an officer, and you were sentenced to serve 90 days in jail, credit for time served, and not to have any contact with Mary Poole. The charge of simple battery involving domestic violence was null prost. It wasn't dismissed or found guilty, but it was just laid back on according to what this says, null prost, and you pled guilty also to the charge of contempt of court, and you were served 30 days for that. What about that fight that y'all got into?
For me and Mary,
Yes.
it wasn't a physical fight. She was fussing at me. Cause I was trying to leave at like 9 o'clock at night, I think. And she was then fussing at me. She was doing all the loud talking. It wasn't nothing but loud talking. And when the cops came, I mean, we tried to tell them that. We both was telling them that, and I ended up going to jail. I didn't get charged with no misdemeanor domestic till the next day. I didn't have charges, but I was in jail till the 24 hours before they gave me a charge.
Well, not really. They charged you with resisting that night.
Yeah, I mean for the domestic thing, they charged me resisting that night. Yes, sir.
Okay. All right. Well, they did some more investigating and thought that that was a valid reason to charge you with the domestic. Okay. So you're saying that you were innocent of the domestic violence?
100%, sir.
But you pled guilty to resisting arrest, resisting
Yes,
all.
Yes,
Okay.
sir.
All right. Number 9, agents been unable to make contact with you at your residence since February 6th of 2024. You've moved multiple times without permission or notification. That's kind of like the first one we read, number 2. Are you guilty of that or not?
I really didn't move. Like, I mean, I didn't even have an address. I was sleeping where I could sleep. I didn't have nowhere to live, sir. I mean, I wasn't running. I hadn't broken a law. I hadn't broken not one law. So why would I be hiding from him? I just didn't have an address to live. I mean, I gave my address, and like in the next 2 or 3 days, I wouldn't even be there no more because I can't stay there no more. I had to find somewhere else to go. So I mean, my address, I don't know. I call him, I mean, FaceTime him, I'm letting him know I'm on the streets. I'm gonna get a job though. Cause I work. I'm gonna get a job. It's gonna change for me. Just hold bad with me. And that's all I could have did. I mean.
Okay. Okay. All right. I think we've heard you. We've heard that part of it. Okay. And you owe $1,008. You've made no payments toward your supervisory fee since being released to supervision. You currently owe $1,008. Is that true?
Yes, sir.
Okay. And why hadn't you?
I didn't have a job. Sir, like for real, I was barely eating in a day. Like, I mean, if you give me a chance to go home, man, I could get on the payments. I could start, I have a girlfriend, she could help me with that. I could get on the payments and start paying.
Who is your girlfriend?
Well, Mary Pooh's cousin. Alicia Pooh.
Mary Pooh's cousin?
Yes. That's what the argument.
Mary Pooh's one you had the argument with and you slapped, according to what you said in the back of that patrol car. You remember that?
I slapped her.
Yes.
No, Mary was trying to slap me. I was grabbing her hands.
Okay. All right. Well, we won't get into all that because I think I've heard enough. Yeah.
I don't have any questions.
Any questions? Okay, Mom, I'm the first one to vote since this particular case was mine to do. I think that you need to spend some more time in jail. I don't think you understand the seriousness of being on parole, the importance of reporting to your officer, and the importance of staying away from any kind of relationships or situations like when you fought this lady. So for that reason, my vote is to revoke because of rules 2, 4, 9, and 10 violations.
Yes, sir. Can I say something before y'all vote me?
No, I think we're ready to vote. We've heard what you had to say, Mr. Tillman.
My vote is to revoke 2 according to the violations that he violated.
Have to read the video and testimony, reading all the testimony and reviewing the supervising agent's notes. My vote is also to revoke based on your violation of conditions of parole.
Okay, that will conclude this hearing. You are hereby revoked. It's 8:55 in the morning. Thank you.
Denied. Dude, let me
Can't understand.
Shocker. Let's go to Miami-Dade, where Judge I don't know who is currently holding first appearance.
And I believe, I don't know what the charges are, but she should qualify.
We're checking that now. It's
Okay.
theft of the elderly. So I'm gonna grant, did she need an interpreter?
No.
Okay. Ma'am, you're charged with theft of the elderly. You qualify for pretrial services, so I'm gonna grant pretrial services. It's one count. And the alternate bond is 15,000. There is a stay away order from Joe Eastla at 10634 Southwest Fifth Street in Sweetwater. Cannot have any contact, direct or indirect. Otherwise, you could be charged with a new offense or it could be violation of your pretrial status. Do you understand that?
Yes, I do.
Okay, good luck to you.
Thank you, Judge.
Okay.
Bye-bye. Have a good one.
Okay, and then Ariana Montana.
Judge, Miss Montana was out on house arrest and she picked up these charges.
Okay. Okay, good. That's it. No, we just keep going. So we have 2A forms? Yeah. All right, Ms. Montana, does she need the services of an interpreter?
Judge, she,
Necesita intérprete.
no, I need to go to the hospital today because I see vision and I hear voice and they don't give me medication. Can you send me to the hospital, please?
Okay, Miss Corey will take care of that. If there's anything along those lines, she'll ask me for an order. She's out on house arrest. Do we put up a hold on house arrest cases? I don't know.
Yes, Judge.
So I'm gonna put a hold on these cases for 25-12357. Felony hold, let me put that on here.
We are on.
Then let's address one by one. The first
It's
one.
2 cases, Judge, that she was out on house arrest.
Okay, thank you, corrections. 2 cases that she's out on house arrest, because I only have one case, 25-12357.
And it's also M25-4174.
4174. M21, is that a misdemeanor case?
Yes, M25-004174.
Okay, so I'll put a hold for the misdemeanor case as well as the felony case. And then in case number F25-14460.
60, Judge, it was a $2.99 beef jerky. There is probable cause, but if Your Honor wants to reduce the bond, that's fine.
Could you do $1 for that case, Judge?
How much?
$1.
$1? Okay, that sounds reasonable. I think there's only one count. Yeah, so it's $1 bond on that one.
That's
And
which
this
case,
is-
Judge?
What?
$1 for which case?
$1 bond on 25-14460 with a stay away order from the CVS at 9578 Harding Avenue. And then in case number F25-14545, you're charged with burglary of an unoccupied structure. There's a felony hold also and a misdemeanor hold, and that's a 3rd-degree felony. So I will set the bond in the amount of, my little cheat sheet, in the amount of $2,500. And there's a stay away order from 9581 Carlisle Avenue in Surfside.
This is no hold on this one, correct? Oh, she's in.
Wait, because we're getting, no, there's no hold.
Okay, so please write in.
No hold.
This is $1,500.
Yes, that's 1,500.
I'll try to make it a little clearer if you're having a hard time. Yeah, sorry about that. Okay. Anais Aviles.
Miss Evelis is also out on felony bond F25-12671.
Present speaks English. Good morning.
Are you Miss Aviles?
I am, ma'am.
Okay. I'm placing a hold on you, which means that I'm going to set the bond on the new case, but you won't be able to get out until the felony judge sees you, for which you're out on felony bond. But in this case, you're charged with cocaine possession and drug paraphernalia.
So Judge, count 1 should be just possession.
I agree.
What's the difference between, oh, because it says
Or
church.
make it a third degree felony?
It's a third degree felony? Okay, so then it would be $2,500 bond on the count one. And misdemeanor drug paraphernalia is what? I'm just gonna say-
500.
I'm gonna set $100 bond on.
Okay. So Judge, on misdemeanors, first degree misdemeanors, force 1,000, no force 500. Second degree misdemeanors, force 250, no force 150.
Okay. Thank you for that, State. Okay, our next case is Ariane Marshall.
Judge, Miss Marshall was seen on her traffic. She was given $1 bond.
She may qualify for pretrial.
Does she qualify? Okay.
One down. Okay.
1,500.
Okay, so this one has a.
Okay, ma'am, I'm gonna grant your charge in this case with grand theft and giving a false name. One is a third degree felony and one is a first degree misdemeanor. On the third degree felony, I'm gonna grant you a program, pretrial services with an alternate bond of $2,500. And on count two, it's pretrial services with an alternate bond of misdemeanor of the first degree.
So it'd be 500.
500, right? So your total bond, the program will take you out. Do you guys get a name and the phone number of someone that can verify her address?
A judge, the pretrial will do that.
Okay.
Thank you.
Okay, good luck to you, ma'am. Melissa Sagendorf. Does she qualify?
Okay, no.
She's homeless, so tap.
But the state's requesting a bond because of all the theft convictions.
Judge, I would ask if you would consider the TAP
I'm
program.
gonna give the tap. Yeah, overstate's objection, I'm gonna grant tap. So it's a third degree petty theft.
She's charged with 2 counts of petty theft.
2 counts, okay, so then, let's see, and that's a third degree. So on count one, it'll be tap over state's objection with an alternate of 2,500. Count two, it's tap with an alternate of 2,500. Count three, drug paraphernalia, it's tap with an alternate of
500.
Thank you, 500.
Good morning, Your Honor.
Count four, it's tap, yeah.
Good morning, Your Honor. Devin Alexander for the record. I am a victim advocate for CVS in this case and also the Michael Meyerhofer case, which is a co-defendant case.
Okay.
I was hoping that I may be heard on behalf of the victim in this case.
Okay, what would you like to say?
Your Honor, Ms. Sagendorf is a repeat offender, as you can see from her criminal history at this CVS specifically, 888 Biscayne Boulevard. I understand that she is homeless and that the court wanted TAP. However, I've been in communication with the store, my client, and Officer Eddie Perez of Miami PD. We were asking for a higher than standard bond. We would ask that the court would consider not giving the offender TAP, as we believe that she will reoffend at this CVS or another CVS. She's been a problem for us, and we would just hope that the court would consider a higher than standard bond, or
No,
just
I'm not gonna grant, how would that avoid her going back?
Your Honor, if she is in custody as a protection to the community and CVS, as she is a multi-time thief
How many
at the
times has she
store.
been convicted of going over there?
Your Honor, it's not necessarily this store, but it's CVS generally. And we would just ask for, as a protection to the community, and CVS is part of the community, that there be something of a bond placed on this particular defendant.
Have all these
5 convictions, the most 4th petty theft, the most recent being in March. There's also a withhold for grand theft in March.
Okay, all right, I've heard enough. I'll just set the standard bond. I'm not gonna
Judge,
elevate.
I
the
would
bond.
ask for tap. It's 2 bags of chips and 1 bottle of lotion on different occasions. I would ask for tap, Judge.
It's
Your
what?
Honor,
A bag of chips?
2 bags of chips on one occasion and looks like a bottle of lotion on another occasion. I would
Your
ask.
Honor,
Judge.
we understand that in this case, it is not a high value amount, but when the offender comes and goes and comes and goes, and every time there's a theft, it does affect the bottom line of CVS, and it is not a victimless crime.
Yeah, I'll just leave the standard bond.
Thank you, Your Honor.
No tap, Judge.
No tap, guys. We'll just
So it's
do-
2,500 for count 4 as well?
Where's 500?
Count 4 was 500.
Thank you, Your Honor. I am also here for Michael Meyerhofer. May I just stay as a panelist and mute myself in my video until he comes up?
Of course,
Thank you, Your Honor.
of course. Garida O'Callahan?
Now, I will have to say one of the problems here, and I don't know specifically what CVS's policy is, but a lot of these corporations have a policy that they will not stop people. They will not pursue them. So they come in, they take stuff, they walk out the door, and then they go to the law enforcement and cry about how, you know, things have been stolen from them. And I'm not saying stealing is right. I think it's incredibly wrong. But don't have a policy that you're not going to, you know, confront the person and say, hey, stop it, give me my stuff back, and, you know, then expect it to just all be okay. Just my thoughts. Let's do this. Let's spend a few minutes in Fulton County for our friend Ashley, and we'll see if anybody shows up that she might know.
All right. Could you put the phone number in the chat directly to participant Doc Upshaw?
If he could just send us his number, so when the phone gets available, we can go ahead and put him on.
Mr. Upshaw, if you can use your chat feature, just put your phone number to participant courtroom 2.
Thank you very much.
All right, thank you. Next case, courtroom 2.
Position 44, Mrs. Scott.
Mr. Masajidin, what are we doing in this case?
For Mr. Scott, Your Honor, we have a non-negotiated plea.
All right. And what is the non-negotiated part?
Just, Your Honor, asking that Mr. Scott not be asked to serve any more time. He's currently credited with 14 days and asked to be served 60. So I believe that would be 16 more days for him to serve. We'd ask for him to not have any more time to serve, to be released on probation, with all other conditions remaining the same. And that is especially in light of Mr. Scott's myriad of medical conditions. He also has a meeting with an official from disability to help him finish the application and qualify coming up in a month.
All right, let's begin then. This is James Scott, case 25 CR 3637B. And Mr. Scott's accused of criminal trespass causing damage to property and simple battery from May 3rd, 2024. Mr. Scott, you've been advised of your rights. Could you please raise your right hand for the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
No.
Yes or no?
Yes.
Thank you. Ms. Falk, what is the state's recommendation for this gentleman?
Good morning, Your Honor.
Oh, sorry. Good morning, Ms. Harrison. Yes, what is the recommendation?
The state's recommendation for Mr. Scott is 12 months probation, served 60 days, credit for time served 14 days. The defendant has been incarcerated since June 27th of 2025. The balance will be probated. No further contact with Stratman Marsh, and stay away from 400 block of Bolton Road Northwest. We are also asking for an MHET or a BHET and completion of 40 hours of community service. And he's charged with count 2, simple battery. The state's recommendation is 12 months probation, concurrent with count 1. Your Honor, briefly to put the facts of the record on the case, officers were dispatched to 491 Bolton Road in reference to vandalism. When they got there, they met with the victim, Mr. Stratman Marsh, who stated that the defendant assaulted him due to a dispute over construction work. Mr. Marsh was supposed to do the construction. Mr. Marsh stated the defendant was supposed to do the construction work for him, and he did not like the finished product and he did not want to pay. After an altercation, he stated that he would pay, but he was assaulted by the defendant by being slapped in the face and punched in the chest and throwing a log into his car window, causing damage to the car. And that'll be all for the state.
All right. Ms. Arjudin, I've already heard your argument with regards to the non-negotiated part, and I'm going to grant the defendant's request. It would be, so he served 14 days, so I'm going to amend it to serve 28 days, credit for time served 14 days, and he would have to immediately report to probation, including to stay away and have no contact with Stratman Marsh and stay away from 491 Bolton Road. If he has any issue with regards to unpaid work, he would need to file a civil case 1 year from now.
Understood, Your Honor. I just also want to praise the court that Mr. Scott has 2 holds, one out of Gwinnett and one out of Clayton County, so that he's not asked to report from probation, immediately tomorrow. But that
he'll have to report within 48 hours of being released from both those locations. All right. Is that acceptable, or would you like to go to trial?
No, Judge, that we graciously accept.
All right. On the, Mr. Scott, have you consumed any medicine or alcohol recently?
No, my medication with my high blood pressure. I'm diabetic.
Okay. After consuming that, are you still able to understand your attorney and what's going on in your case?
Yes, Your Honor.
And are you satisfied with your legal services?
Yes, Your Honor.
And has your attorney explained to you that if you decide to plead guilty to these charges, you will have to give up your right to a trial? You will not go back to court to confront your accuser, challenge evidence that'll be brought against you, to be able to present your legal defenses and arguments, and the prosecutor won't have to prove the charges beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of criminal trespass causing damage to property and 1 count of simple battery?
Yes.
Your sentence for the trespass is going to be 12 months to serve 28 days, credit for time served 14 days. As far as your jail time for this case, that would be concluded, and either Gwinnett or Clayton County will have to come pick you up. And as soon as you've resolved your holds, you would need to report to Fulton County probation within 48 hours. If you do not report, we will issue a probation warrant and you'll be right back in jail. Do you understand?
Yes, Your Honor.
All right. While you, once you've completed your holds and you are on Fulton County probation, you will have to make sure that you have no contact with Stratman Marsh for at least 1 year, and you're to stay away from the 401 Bolton Road in Northwest, 200 yards away. So it'll be the entire 400 block at Bolton Road. You cannot be seen anywhere near that location. Within 30 days of reporting to probation, you will then undergo either a MH evaluation or a BH evaluation. Your probation officer will explain to you what that means unless you already know what that is. Has your attorney explained that to you?
No.
Refresh his memory, Mr. Masarjuddin, if you want to mute.
Thank you, Your Honor.
All right. So do you know what that is now, Mr. Scott?
Yes, Your Honor.
All right. So within 30 days of being on Fulton County probation, you must show proof that you've made an appointment for an MH or BH evaluation. The option's up to you, but one of them must be done. And you're also to complete 40 hours of community service with any nonprofit agency. It cannot be a church and it cannot be a school. So you can go to Veterans Society, you can go to Animal Care, you can go to Goodwill Salvation Army. It just cannot be a church and it cannot be a school. And you must do your community service at a minimum rate of 5 hours per month. until all 40 hours are done. For count 2, it will be 12 months concurrent with count 1. 12 months probation concurrent with count 1. Thank you.
Thank you, Judge.
Ashley, you're a lot like Mrs. TCF. She will find the most obscure facts on a person out of nowhere. I don't know how she does it, but you're doing it too. So thanks for sharing and teaching us a little more about Judge Lal. Let's go back to Louisiana.
Good morning. We're at the Department of Corrections headquarters in Baton Rouge. We're continuing with some of our hearings. We now go to Rayburn Correctional Center, and we appreciate y'all being there. We've introduced ourselves, but you can see from our name tags exactly who we are, but I think we're all familiar. Warden, would you introduce everybody that's in your room there, or get them to introduce themselves, please?
Yes, sir. Warden Travis Day.
Kristen Herbert, Records. Gracie Williams, Classifications.
Assistant Warden John Smiley. Okay, thank y'all for hosting us this morning. We appreciate that. And we're talking to Mr. Brian Leto. Is that you, Mr. Leto?
Yes, sir.
Okay, what is your DOC number?
It's 577-395.
Okay, all right. Well, we appreciate that. Well, the way we conduct these hearings is we give you first shot at exactly telling us what you did, why you're there, and what you've done since you've been incarcerated, and try to convince us that you are worthy of being released early. And then we're going to go to the warden and ask the warden to speak on what he knows as far as your behavior since he's seen you in the institution there. Then we've got some folks here in headquarters here that want to speak also in opposition. We don't have anybody speaking in favor except you. So, Mr. Leto, now is your chance to try to convince us that you're worthy of being released early. Go ahead.
Okay, I'd like to begin, first of all, by offering my most sincere apology to my children, Scott, Shannon, and Sarah, and my family and friends as well. I apologize for putting them through this ordeal. Although my kids are not part of my life right now, I continue to pray for them every day and hope they find a way to live happy and fulfilling lives. I will always miss them every day and understand that I brought this upon myself. Since being incarcerated, I've done all of the programs that the state has required me to do, additional self-help programs as well. And I've had no write-up since I've been here, so I've been a mentor and help other inmates on the facility.
Okay. What kind of courses, what kind of education have you taken there?
I've already had my GED when I arrived, but I've taken Living in Balance, some Toastmasters programs, as well as major aid. Sorry, I couldn't think of the name of it.
Okay. Warden, what can you tell us about his behavior since you've known him?
Yes, as far as being here at RCC, he's worked in the kitchen for 9 years, so he's had a pretty constant, stable job in there with no disciplinary issues. And as far as an inmate, has been a model inmate.
Okay, thank you, sir. I appreciate that. Okay, we have three family, victims' family that are going to speak, and they'll be speaking from headquarters here. And we'll start with, we're going to have Seth Kleiner, Shannon Falco, and Sarah Leto. And I'll let y'all decide who wants to speak first. And if you would, try to limit your remarks to 2 or 3 minutes or whatever, and let us know what your feelings are. Introduce yourself, please, ma'am.
My name is Sarah Leto.
Okay.
Whenever I think of my childhood with Ryan, it's never once been any form of a good memory. It's always come with feelings of sadness, betrayal, depression, and loneliness, just to name a few. Things that I still deal with every day. These are emotions that a father should never make a child feel. Yet Brian made me feel that way with every memory of him, and still makes me feel that way today as I say this. His actions have impacted my life so negatively. As a child, I had to learn how to deal with the horrible trauma of Brian and he put me through. I had to be way stronger than any child at that age should have to. Countless nights I sat there and wondered why couldn't I just have a dad that loved me. To this day, I still struggle with trust issues. I struggle as a mom every day. I struggle trusting anyone around my daughter. I'm not around assuming since my own dad could hurt me so badly, someone will try to hurt her as well. I hate to think that one day I will have to sit her down and answer why I never got to have a dad. I continue to struggle with the effects from what Brian did. Him serving the time that he agreed to is just a fraction of what he actually deserves. I'll never get my childhood back, and unfortunately, I'll never forget what he did. He doesn't deserve to get a second chance because I never got a second chance. What he did is disgusting and unforgivable.
Thank you. Appreciate your comments there. Okay, who is going to speak next?
My name's Shannon Falco. The sexual abuse that I've endured for most of my childhood ended more than 2 decades ago, but I deal with the emotional and physical effects daily. Most of my adult life has been spent trying to recover, heal, and find some sense of normalcy. Currently, I deal with a variety of issues, including but not limited to the following: depression, anxiety, low self-esteem, feelings of worthlessness, disordered eating, chronic headaches, nightmares, flashbacks, triggers, panic attacks, thoughts of self-harm, extremely negative body image issues, and problems with intimacy. I've had to leave work because a flashback was so intense that I couldn't breathe. I've been in certain places, had a random flashback triggered by something I was unaware of and could no longer return to that place. I have seen a number of therapists and have been unable to find one that is a right fit for me. This is also an expensive and time-consuming process, which puts a burden on me financially. Even today, seeing him is going to be a very intense trigger for me after this. I genuinely believe there is no punishment to fit such a terrible crime, but I'm also 100% in favor of the maximum sentence allowed. This person stole my childhood from me. He helped bring me into this world only to ruin my life and steal my innocence, my life, my hopes, and my dreams. He not only destroyed my childhood, but he managed to totally and completely negatively affect my adult life. As much as I would like to believe that when the physical abuse stopped, the pain also stopped, I know firsthand this is not the case. In many ways, the physical abuse was less damaging than the after effects. Just the fact that I'm saying that is a testament to how damaged I really am. I will never know the person I could have been. I will never know what life would be like without constant suffering or physical and emotional pain. Unfortunately, I'll be dealing with this for the rest of my life. This abuse has ruined my life, and although I could finally see that this was in no way my fault and continue to try to move forward and live a happy life, I can also say that this situation has been incredibly unfair to me. I'm angry that so much has been taken from me, and how brutally exhausting it is to work so hard just to try to feel whole and normal. I ask you today to please see that this person is where he belongs, where he's not a danger to me or any other member of society. I will never get back what he stole from me. I am heartbroken. I'm sad, I'm angry, and I will spend the rest of my life trying to recover. I thank you for the opportunity to speak today.
Thank you, ma'am. Appreciate you being here. Appreciate that. Now we'll hear from Seth Kleiner.
I'm Seth Kleiner. I'm Sarah's husband, 18 years. In that period, I have seen how Brian's actions have affected her. I've also gotten to know Shannon and have talked to her about the effect his actions have had on her. They are both strong and amazing women that were forced to become stronger than they ever should have been. I have personally seen the distrust of any new person that Sarah has. When I asked her about this, she said she is this way because if her own dad could do what he did, then who knows what a stranger would do. Throughout the years of knowing them, they have never told me one good thing about him. Never once instance of feeling loved. Only fear that what he was doing physically and mentally would never stop. As a father, it absolutely sickens me to hear the things that he did. Where a father is supposed to protect and love his child, he did nothing but scare and hurt. These women have come very far and have worked very hard to not be constantly affected by his disgusting actions. Every time they have to come here and discuss this, it does nothing but hurts them more each and every time. Thank you.
Thank you, sir. Appreciate that, and we'll keep those comments in mind also. Your case, Mr. Leto has been assigned to Ms. Ledoux, who is on my right, and she'll be the one that's going to be asking you questions.
Mr. Leto, after reviewing your file, and I cannot find any programming certificates after 2019. Have you taken any classes since 2019?
Were you referring to sex treatment offender programs or?
No, any. So when did you take the Madison Tech class?
It was probably back in 17 or 18.
Right. Okay. So I can't find any kind of classes, no certificates after 2019. You finished phase 4 in 2019. The
Right.
facility, can you,
I'm sorry.
can you confirm that?
Yeah, I don't know the exact dates. I believe the two programs I had mentioned may have been after that. I had copies of certificates that I submitted. I'm not sure the exact dates though.
Well, I'm looking at all of those certificates and there's nothing after 2019. So it looks like, so what have you been doing with your time? What is your duty status? What do you do with your time?
No, I'm a cook, a full-time cook in the kitchen.
Okay.
And I've been there for 9 years.
What are your plans were you to be released? What would your plans be?
Well, first of all, my address has been approved already, pending my release, and I look to find work and be a producer in society and earn my independence as quickly as possible, so I wouldn't have to rely on anybody.
So where was your address plan?
It's in Lacombe, Louisiana.
Where?
Lacombe, Lacombe. Yes, ma'am.
What is? How can you overcome this kind of opposition?
And it would be extremely difficult. At the time all this occurred, I had a bad addiction to pornography that led to all of this. But I went through treatment and I've gotten beyond all of that, certainly. But obviously my children have not gotten that far. And I'm sorry to hear that.
How many children did you have total?
3.
2 girls or 3 girls? A boy.
3, 2 girls and a boy, yes, ma'am.
I don't have any other questions.
I don't have any questions. All right, I think it's time to vote now, and Ms. Ledoux will start out the voting for us.
Mr. Leto, your full-time date, according to my record, is 2030. At this time, my vote is to deny parole. You will be released at that time.
My vote is also to deny because of strong family opposition.
And that's 2 votes, and my vote also would be to deny because of victim opposition, because of the type of the crime that occurred. That will conclude this hearing, 9/21.
You know who else whined and complained about having an issue with pornography and how it caused him to do everything right up until the point where he was executed? One Theodore Robert Bundy. He tried to sell that right up until the very end, and most people didn't buy it. Let's go back to Judge Boyd.
CR 0039110, State versus Jordan Armstead. Could I have parties announced?
For the state of Texas, Your Honor. Joseph Stateson for defendant.
And are you Mr. Armstead?
No.
All right, so we had began the plea and then we reset it for possible PTD.
Correct, and I provided ADA with some certificate, high school diploma, few nice words to say about my client, and unfortunately, we're not able to obtain a PTD offer. However, ADA Galloway did revise the offer. There's initials with her initials, my client's initials on the plea bargain.
Sorry, what?
We modified and we initialed next to the modifications for the length and reduction of community service hours. And ADA Galloway is, as long as Mr. Armstead does everything okay on deferred, she's okay with early termination.
All right. So, counsel, you received all discovery?
Yes.
Reviewed it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. For some reason, here we are. Did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes.
Counsel, did you review the true bill of indictment with your client?
Yes, Your Honor.
Mr. Armstead, did you understand the true bill of indictment? All right, you threw me off with your shirt that says no risk, no reward, monopoly. Okay. Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, the last time we were here, I believe you were proceeding on count one, waiving count two. Is that still the same?
I believe so. Yes.
All right. Mr. Armstead, did you review the court admonishments with your attorney? Did you understand it?
Yes.
All right. You're charged with unauthorized use of a vehicle. That's a state jail felony. Range punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Armstead, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count one. There's a $0 fine. State is recommending deferred adjudication. They're taking in consideration 2025 CC 001622. There's to be restitution of $1,200 to Sincer, SINCER Mendoza. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours community service restitution, no contact with the complainant, and the life skills course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense and count one, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State author states exhibit 1 and all attachments else.
No objection.
All right, state you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we ask that you follow the plea bargain agreement. We did come to an agreement regarding restitution to Sinclair.
Is it Sinclair or Sincere?
Sincere, I believe.
Okay.
And there were some documentation about wear and tear, tire worn out. But we agreed with the state that there would be no fine, that we would agree to a fixed amount. We just, if the complainant ever seeks additional, we would want a restitution hearing. We're not agreeing to anything other than the
$1,200.
$1,200.
Well, that's the amount of the restitution that you all have agreed to. So that's the restitution amount. So there will be no further restitution. If there's further restitution, that's something that needs to be handled civilly.
Yeah,
because your
Judge.
agreement is, this is the restitution amount.
I just wanted it on the record.
All right.
Yes, Judge.
All right, are you employed?
Yes.
What do you do?
Waterbury.
Oh, okay. Do you have any children? Do you live by yourself or with someone?
Stairs.
I'm sorry?
Stairs. I got like a roommate.
Oh, okay. So what are your plans for the rest of your life?
Work and in my basketball career.
All right. So this is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home healthcare provider or with minors, 100 hours of community service restitution. My understanding you have your GED or your high school diploma?
Yes.
All right. I'm going to order 200 hours of community service restitution. You can do those 200 hours, or you can get a trade school certification, or if he decides to, if you become manager at Whataburger, then I would consider the community service hours satisfied. And let me just tell you why I'm doing that. We all should be working on improving our life. I know I don't look down on people because they work at Whataburger, because we need people to work at Whataburger. But I've seen plenty of documentaries or stories where people work at McDonald's or Whataburger, and then the next thing you know, they're the manager, and then the next thing you know, they're owning part of the franchise. So I don't want you to just be complacent with where you are. If you have hopes and dreams to do something other than what you're doing, I want you to have the tools to do it. So you can spend your 200 hours, they'll put you to work outside on the roadway, picking up trash in the hot sun, or either you can spend those 200 hours improving yourself by getting your trade school certification, or always showing up on time for your work, and they'll probably make you a manager. You understand? So trade school certification, or if he becomes manager, there's going to be field visits 1 time per month for 3 months. Probation, there's to be restitution of $1,200 and no contact with first name Sincer, last name Mendoza. Taking consideration 2025 CC 001622. Probation, is there anything else? Is there anything else you need from the court in order to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. If there's something that you need, make sure you let probation know about it. If you feel they're not addressing it, you can always come back to the court. All right, good luck.
And Your Honor, I know that it wasn't on the agreement, but the ADA was okay with early term. Will you be able to notate that?
Oh, I tell you what, if those community service hours are either completed, or if he follows through with the trade school certification or higher level education or becoming a manager, I will of course consider it.
Thank you, Judge.
Thank you. Ricardo Reyes.
Good morning.
Good morning. How's it going?
So far, so good.
You know, they used to have this joke about somebody falling from a building. They said, "How you doing?" And they said, as he went through the windows, he's like, "So far, so good." Yeah, you know the joke I'm talking about.
I feel like that.
Yeah. You know, they always say it's not the fall that gets you, it's the landing. All right, so where are we on this case?
Oh,
He's got another case that's not as died yet. I need to look at that as well and potentially maybe this to the global offer as I can to the bench. So if I just could want more setting before that, so I'll get that to you.
All right, and what is the other case?
It's another.
All right, Mrs. Ferguson, if I can have a 30-day reset for discovery, please, on Reyes.
I can do August 12th.
that should be fine.
All right, we will see you back on August 12th. Do you have any questions?
No, Your Honor.
All right, thank you.
Thank you, Judge.
David Dunderlin.
Present.
Yes.
Morning.
Good morning. What page is David Dunderlin on?
Oh, I don't know. It's pretty early, I think.
He's on page 3 at the bottom, Judge.
All right, thank you.
He's got a thing with violence.
All right. So today is your plea deadline date?
So Judge, I've been conferring with both sets of prosecutors because he has the indicted CTD case, plus he has a pre-file domestic violence case.
Mhm.
What we're all asking is for one more plea deadline setting because they don't have an answer on their family violence case as to what they might be able to do with it. There's a chance it's going away. So I would ask the court if we could have another few weeks maybe to give them the opportunity to see what they're going to do with it.
All right, Ms. Ferguson, set this for August 12th.
Yes.
You need to know what's happening by then, okay?
Yes,
All right,
ma'am.
thank you.
That's perfect. Thank you. May we
Thank
be
you.
excused?
Yes, and thank you for dressing appropriately for court. Once you sign the reset form, you're excused. And thank you for being on time.
Thanks. Thank you.
Who is here on Jose Martin Garcia Corona? Good morning. Hi, where is he?
He was taken into ICE custody some months ago, and I don't know the status of that case as of yet.
Okay. State, hi. She's saying her client is in ICE custody.
Yes, and I believe both parties may have difficulty determining status, like location. Is the defendant here? Is defendant somewhere else? We don't know if the court has resources to determine location. I do believe defense has tried every avenue available to them to locate defendant and have been unsuccessful. The state isn't here to move on the case today, not knowing where defendant is. if both parties knew location, we may be better able to come to a resolution.
All right, I'll find out his location if there's no objection.
Please, Judge.
All right, so we'll call it back on August 12th. I would be able to do it today, but I have a funeral to attend today.
I'm sorry to hear that.
Oh, thank you. So it'll be August 12th.
Thank you,
And
Judge.
Thank you, Judge.
I'll discover the location.
Thank you.
You're welcome.
All right, let's change it up a little bit. On the bonus stream we did in the 4th of July, we went to the jail magistrate court in El Paso, and we found this judge that we really liked, and he's back in the chair today. So let's spend a few minutes there.
Let's start with some housekeeping matters. We have 4 BMVs as far as I know. Apodaca, Carrasco, Ortega, and Rodriguez. Okay. Those 4, and then I need to review for me, Ms. Calhoun, if you're going to be asking for 3 days on Mr. Paul Gonzalez, the guy with the 4 ag assaults. Muted. Ms. Calhoun, you are muted.
Sorry about that. Yes, absolutely. I will be requesting a 3-day for Gonzalez.
Okay. So
And who is the first BMV?
it was Apodaca.
Okay.
All right, so let me just put it here, reset, or you can reset it for Monday, which would be, there's a 10th. Tell me if I'm wrong, but I think it's the 14th, okay, 7/14 at 1:30 p.m., okay?
Judge, do you know who was appointed?
Your office is appointed on him, Ms. Cabello, okay?
And so it's a reset for when?
Monday at 1:30 p.m., Monday the 14th at 1:30 p.m.
Okay. I'm so sorry. Is the first one Porras or?
No, the first one that they pointed out is Apodaca.
Oh, Apodaca. Okay.
Apodaca.
Got it. Also, I have a question about the plea hearing whenever you have a second.
What's up?
Okay, so I'm in contact with Mr. Mullins, and we're both wondering if we could actually move the time to right after this bond hearing is over.
Let me see, because the defendant's at the annex.
Oh, okay. If it's too much work, don't.
Yeah, I'm kind of I'm dependent on them, and it's kind of hard to move the wheels over there, okay?
That is totally fine. We'll keep, yeah, I wasn't sure if we're going to be going to the annex today and
That's a little early, so maybe like around 10:45 to 10:50, okay? Because my max.
Gotcha.
Good.
Okay, no worries. No
All right.
worries at all.
Okay, downtown, whenever you're ready.
Your Honor, it's gonna be Gonzalez first.
Okay, who's that?
Gonzalez?
Which Gonzalez?
Gonzalez Paul?
No, he's gonna be canceled for a day. We're gonna reset it for next Monday, okay?
Okay, next is gonna be Reyes.
Thank you. Give me just a second, because I need to look something up on him real quickly here. Nine, 6, 9, 6, 5, 9, 2. Okay. All right, so Mr. Reyes is here on a charge of criminal trespass. Apparently, he was on PR bond. His PR bond got revoked because he got rearrested on so many charges. However, he's already disposed of those charges, at least one of them, the misdemeanor case. Apparently, he got picked up on another criminal trespass, and apparently he pled to probation on 6/26 of this year. This morning, on this case, you set for a bond reduction hearing. Your permanent attorney is a public defender's office. This morning, Ms. Quevedo from that office is going to try to convince me. Then I'm going to hear from the prosecutor, Ms. Calhoun. Then I'll make my decision. All right, Ms. Quevedo, go ahead.
Thank you, Judge. May I proceed by question and answer?
Yes, ma'am.
Okay. And I'm sorry, what was the reason for the PR revo?
basically rearrested for an assault security officer and then a new criminal trespass. But on a new criminal trespass, he played out and got probation at the end of June.
Without resolving this?
I'm sorry?
Without resolving this?
Yeah, apparently so.
Okay, Mr. Reyes, if you're released from jail, where would you live? What's your address?
With my mother on Fairbanks. I don't remember the addresses exactly. I never got a hold of my PR officer, my PR bond officer. I never got heard back from Jessica Morial.
Sir, just answer the questions that your attorney's asking you, please. Thank you.
How long have you lived in El Paso?
Several years.
Are you a U.S. citizen?
Yes, ma'am.
What is the highest grade of school that you finished?
Some college certificate.
Where did you graduate from high school?
Coronado.
And then you went on to what college?
Henry's UA.
Where is that?
In Alamogordo, New Mexico.
Okay. Do you have any children?
No, ma'am.
Do you have any family here in El Paso?
My mother.
Sorry, besides your mother?
My brother.
And do you work?
Do I? No, not currently.
Do you have any money that you can pay to bond out instead of being on the PR bond?
No, I do not.
Do you have a phone number where you can be reached if you are released?
Yes, it's 915-224-3318.
All right, Mr. Hayes, thank you. Your Honor, based on the information provided, we're respectfully requesting a PR bond or any relief the court might find fitting. Thank you, Judge.
Ms. Calhoun, just tell me where this criminal trespass occurred at.
Yes, Your Honor. This occurred at 9441 Alameda.
All right. Well, I'm gonna give him a PR bond. It's gonna be under enhanced level supervision. You're already on probation, man. You screw it up this time, you're probably gonna be sitting here for a long time. So keep that in mind. So it's gonna be enhanced level supervision with the following conditions. One, defendant must report to his supervision officer as instructed. So you're gonna be reporting both to a probation officer and a PR bond officer. So I don't want to hear it later on. I don't know, I was supposed to report to a PR bond officer too. Two, you cannot be rearrested for any new offenses while this case is pending. And you cannot go to any Walmart in El Paso County, Texas. Do you understand?
Okay, yes, sir.
All right.
This is for the Crunch Gym.
Yes.
This is for the Crunch Gym and the Walmart?
You cannot go to any Walmart, sir, period.
Because I was told when I was arrested it was for the Crunch Gym
Sir, you cannot go to any Walmart. That's a condition of your bond.
Okay, yes, sir.
All right, Ms. Lopez?
Thank you, Judge. Sir, do you have an email address?
No, I do not.
Do you have a phone number for a friend or a relative?
For a relative, is 915.
Number belong to?
Virginia Cabero.
Is that your mother?
Yes, ma'am.
And do you have a personal phone number?
No, I do not.
Okay. Thank you, sir. Thank you, Judge.
All right, thank you.
Sorry, Judge. For that one, I believe the affidavit does say the Crunch Fitness at 9155 Dyer Street.
Says what?
That it was at the Crunch Fitness gym in
Okay.
9155 Dyer Street.
Also put that one in there, okay? Because sounds to me like he's got in both places, okay? So put that place also. Thank you.
Thank you.
So no Walmart and no that fitness place. All right, next. Let the officer know you're done, sir. Thank you.
We're done, man.
Thank you. What is your name, sir?
Juan Carlos Porras.
Last name?
Porras.
Okay, so Mr. Porras is here on a charge of possession of controlled substance, penalty group 1, less than a gram with a $2,000 bond. The permanent attorney is a public defender's office. This morning, Ms. Quevedo from that office is going to present evidence on your behalf. to try and convince me to lower your bonds. Then I'm going to hear from the prosecutor, Ms. Calhoun, then I'll make my decision as to what happens to your bond. Go ahead, Ms. Cabedo.
Thank you, Judge. Your Honor, Mr. Porras indicated that if he's released, he would live at 3007 McKinley with his mother. He's lived his entire life in El Paso. He is a U.S. citizen. He went to Eastwood High School where he completed up to the 10th grade. He has his mother, his siblings, aunts, and uncles in El Paso. He does not have any money to post, but he can be reached at 915 our bond or any relief the court might find fitting. Thank you, Judge.
All right, Ms. Calhoun, prior criminal history.
Yes, Your Honor. I'm seeing here on my end, criminal trespass, some misdemeanor drug charges, UUMV, burglary of vehicle, a couple of those, assault, family violence, violation of protective order, as well as evading and pending cases.
All right.
And there's like probably about 4 or 5 BOVs.
Yeah. No, I see he's been active. Basically, he's had 0.42 grams of fentanyl. That's what the
Yes, sir.
concerning for the court is apparently he's been on PR bond before and he's gotten his PR bonds revoked. So obviously he doesn't like to comply with court orders. All right. There's gonna be an intensive level supervision PR bond, and I'm not playing games with you. You follow these conditions, because if you don't, come back in front of me. Don't even bother. Okay. Condition number 1, you must report to PR1 officer as instructed. That means you will report when they tell you to report, not when you feel like reporting. Condition number 2, you cannot be rearrested for any new offenses while this case is pending. Conditions 3 and 4, you're not allowed to possess or consume illegal drugs or alcohol, and when you report, they're going to be testing you. You understand?
Yes, sir.
Ms. Lopez?
Thank you, Judge. Sir, do you have an email address?
I do not.
Do you have a phone number for a friend or relative?
Relative,
Okay.
which is the 915.
And who does that number belong to?
My mom,
What's your mother's full name?
Marisela Porras.
And do you have a personal phone number?
I do not.
Okay. Thank you, sir. Thank you, Judge.
All right, so here's what's going to happen. You're going to get released today. You're going to get a piece of paper. That piece of paper is going to have a phone number, a date, and a time for you to call to do an orientation. Make sure you do it, because if you don't, that's a violation of your conditions. Thank you.
Thank you.
Let the officer know that you're done, sir. Thank you.
All right. Yes, sir.
All right, let's head back up to Michigan. We'll spend a little more time with Judge Simpson. By the way, I really like that El Paso guy because he's completely no nonsense. But let me know what you think in the chat.
Record. Oh, see here. I'm sorry. He's in custody.
Hey, Don.
Your name, sir?
Anthony Alfaro Callejas.
Thank you. All right, what are we doing?
Your Honor, my understanding is that counsel just submitted a substitution and needs time to get discovery review with his client. So I believe they're requesting an adjournment.
Your Honor, that is a fair and accurate statement. Negotiations are being continued. We would respectfully request a brief adjournment.
They didn't tell you anything about green sheets. You'll need to fill out the green sheets. I'll grant the adjournment. Would the 22nd be enough time, counsel?
Thank you.
Will that be enough?
That should be enough. Thank you.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond continued.
With me.
Thank you, Your Honor.
Thank you. Courthouse case, People versus Roderick Bates.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Bates, who should be appearing via Zoom.
Good morning. Your name?
Roderick Bates.
So, Your Honor, the prosecution's recently provided some additional video discovery we were just able to get from Washington County. So I just need time to review that with my client. So I'm requesting an adjournment.
Probable cause conference. Do you have a green sheet for me?
Yes, I do, Your Honor.
July 22nd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Sorry. Calls the case of the People versus McNally Fox.
Good morning, Your Honor. Ellen Dennis appearing on behalf of Molly Fox.
Your name?
Molly Fox.
You're requesting, well, is she gone to inpatient treatment yet?
She hasn't gone, she's still in custody, Your Honor. You
I know.
signed the order yesterday, I think. And it has some contingencies in it that there has to be a bed. She believes there will be, but we don't know yet. Also, I could tell the court that she's been interviewed by Mr. Reyes with a review of whether she'd be eligible for recovery court. And I do not know what that decision is because I haven't received the email yet from him. That happened, was it yesterday? Day before yesterday? Tuesday.
Your interview happened day before yesterday?
Yeah.
Okay, they should be coming out, hopefully with a decision relatively soon. I can give you the 22nd or the 31st, counsel.
Pardon?
The 22nd or the 31st, which date would you prefer?
The 31st. Now, I assume that if the bed becomes available, she can go and still.
She'll be an inpatient and we'll deal with it, but I mean.
Okay.
I'm not gonna hold everything up on that. Probable cause conference, July 31st, 2025, 9 a.m. Bond continue. Thank you. Thank you.
Your Honor.
Court calls case People versus Elton Bell.
Good morning, Your Honor.
Kerma Dadush on behalf of Mr. Bell. Mr. Bell, can you please state your name for the record?
Elton Robert Bell.
And good morning, sir. All right, what are we doing?
Your Honor, I did submit a green form, but we are actually not going to be adjourning on this case. We are going to be waiving preliminary examination.
All right, Mr. Bell?
Yes.
You're gonna waive your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
And you understand you'll not have that hearing, you'll proceed to circuit court for further proceedings?
Yes.
People also waive their right?
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over on a single count.
We waive formal reading of the charges and stand mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 28th, 2025 at 1:30 with Judge Slay.
August 28, 2025, 1:30, Judge Slay.
Thank you so much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Bond will continue. Court calls case People versus Ardeen Henderson.
Hey, everyone.
Kerma Dadush on behalf of Ms. Henderson. Ms. Henderson, can you please state your name for the record?
Yes, my name is Ardeen Beatrice Henderson, Grand Rising. Thank you all for having me.
You're welcome.
Your Honor, we are going to be asking for an adjournment. We have just started the aim mitigation process. So we're going to be asking for an adjournment for that purpose and plea negotiations.
Your Honor, I would just remind the court, this person does have a case in Wayne County. She's got a case at 35th District Court, where she's referred for competency in May. That report has not come in based on measure of actions. And that report is for August 29th.
August 29th. So were you aware of that, counsel?
Yes, I was. She had told me that she started that process.
Okay, well, then I'm a bit reluctant to do anything prior to that competency report coming through. So
Are we able to adjourn further out?
I'm able to do a lot of things. Some of the things I will not do.
Whatever your honor prefers.
Of course, you're learning. Give me a September date.
September 11th.
September 11th.
Can she hear us?
I will adjourn. Can you hear me, ma'am?
Yeah, I just don't understand what's going on. Can somebody please explain to me, please?
Okay, so I'm adjourning it out. Okay, my understanding is that there's a competency review in your other matter.
Okay,
Okay, so
Okay.
what we're doing is we're taking the safe course of this, putting this out till after there's a finding there, because that may dictate what happens here. We really can't get much done until that comes through.
okay, well, my lawyers better explain to me later also again, I won't forget. Or can someone send me something or something if I can have someone read to me what's going on? Okay, never mind. The sergeant here said, Sergeant Perzon, how you pronounce your name? Porzondek said he'll help me. He explained to me.
Okay, and your attorneys will be in touch with you, okay?
I can talk to you next week, Ms. Henderson, okay? To explain all of this.
Thank you.
Okay.
I thank you all for having me.
Yes.
Okay,
We are so glad, and we will
Thank
have you
you.
back in September 11th, 2025 at 9 a.m., okay?
Take care, Ms. Henderson.
Bond
For
continued.
my birthday, and what day would? I'm
That's
sorry,
your
what day
birthday?
would that be?
September 11th.
September the 18th. That's right before. Okay.
September
That's on a
18th, your
Tuesday.
birthday? Well,
Maybe
so I
yes.
don't forget, happy birthday.
Thank you. I'm taking my grandkids to the water park before it gets cold. Thank you.
Okay, take care.
Thank you.
Court calls the case, People versus Orby Huffman.
People.
David Burgess on behalf of Orby Huffman.
State your name, sir.
Orby Huffman.
Thank you. What are we doing?
Your Honor, we've received discovery in this matter. We're requesting an exam be scheduled.
People have their witnesses available the 22nd. Preliminary examination in this matter will be set for July 22nd, 2025 at 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond will continue. Thank you. Does call the case of the People versus Nathan Bell.
People.
Assistant Public Defender Nick Bukovich for Mr. Bell, who should be appealing via Zoom.
Nathan Bell, do we have him?
No, I do not.
I was in contact with my client this week and he asked me for that Zoom request.
He did?
Yes.
I'm here.
So,
I'm here.
He goes by another name, Motorola. Sir, I need you to turn on the camera, please.
Yes, sir. Yes, am I here? Yes, I'm here.
Okay, you have to uncover the lens. There you go.
There you go.
What's your name?
Nathan Bell.
All right, what are we doing?
I'll be requesting a brief adjournment for Mr. Bell to obtain some medical documentation I can provide to the prosecution towards an offer. And I do have a green sheet, Your Honor.
July 31st, 2025, 9 a.m. Bond continued. Court does call the case People versus Jonathan Miles. Oh, there she is.
Good afternoon, I'm sorry, good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Good morning.
And Alex Warren Green on behalf of Mr. Miles. Mr. Miles, can you state your name for the court?
Jonathan Dion Miles.
All right, what are we doing?
Your Honor, I had an opportunity to confer with the Assistant Attorney General. She did extend a generous offer, but at this time, Mr. Miles is asking for a preliminary examination.
I'm sorry, who in our office did you speak to?
I emailed you, Ms. Williams, and received a return email as well.
Okay. I don't recall that, but okay, I'll look through my emails.
All right. You want this set for exam?
Mr. Miles is asking for a preliminary examination, yes.
All discovery is complete?
Believe so, Your Honor.
Would the people have their witnesses available on the 22nd?
We should, Your Honor. I'm sorry.
All right.
What is the defense attorney's name? He's saying he sent this email. I don't remember having a discussion. Was this shortly after the last hearing about this case? I know we hadn't made an offer at the last hearing.
My name is Alex Warren Green.
Okay. I'm not saying that you did.
No, I get you. How much is owing on this?
Your Honor, I believe it's just north of $6,000.
And so the exam is going to be over what's owed?
Your Honor,
Making the law that if it's charged, it's owed?
Talk to my
That's
client.
okay.
I advise
We'll
I
set it.
advise him of the offer.
We'll set the exam.
Thank you.
Preliminary examination in this matter in person will be set July 22nd, 2025. That's at 12 noon, and that's before me.
Thank you, Your
So if
Honor.
we set it for exam, Mr. Warren Green, you better come with something.
Thank you, Your Honor.
Court calls the case People versus Daniel Bowe.
Assistant Public Defendant Nicholas Bukovich for Mr. Bowe, who is approaching.
Your name?
Daniel Bowe.
Thank you.
At this time, Your Honor, we requesting a brief adjournment. The prosecution has extended an offer. It's just Mr. Bowe wants to confirm that this offer won't have impact on an outside matter before accepting it. So.
Probable cause conference, July 22nd, 2025, 9 a.m.
Mr. Bowe did want me to ask if we could do a possible further out adjournment because he'll be up north for work from July 19th to August 5th. I did explain to him I could ask that, but it's ultimately up to the court.
Yeah, I'll be up by Mackinac working for about 2 weeks. And I don't want to miss court and have anything come back on me because I'm 4 hours away. If I have to make that adjustment, I will, but I'm just asking.
Oh, I know. When are you coming back now?
August 5th, I'll be back.
Any objection from the people?
No, Your Honor.
Thank you.
August 7th, 2025, 9 a.m.
Thank you, Your Honor.
You're welcome. Bond continue.
Thank you, Your Honor.
Let's change it up again a little bit because it's been a while since I've been there. This is Adams County, Colorado, where they are doing bond hearings.
You in. So think about that right now. And should we should we go ahead and order a writ now?
I think it's best to request a writ now, and if it's not needed, then
All right, Mr. Hoisington, in both these cases, the people are instructed to go ahead and writ from Arapahoe County. That would be an in-person writ, please.
Will do, thank you.
Okay. Willie Scheider.
Good morning.
Good morning, Mr. Scheider. Mr. Scheider, you are being held in Adams County Case 25M3569. Your next court date will be in the First Appearance Center on July 17 at 1:30 for an arraignment.
All right.
Now, the district attorney has no objection to a PR bond. That will be a $1,000 PR bond. Keep in mind, there is an active protection order that prohibits you from having any contact with Ms. Escobedo Mabane. I'm not issuing another order today. There's already a valid one in place. Should you come back on another violation, however, you will not receive a PR bond. Do you understand?
Yes, ma'am.
Thank you. Letitia Terry. Good morning, Ms. Terry. Ms. Terry, you are being held in 25 CR 1911. Your next court date is in Division R2 on July 14 at 1:30 for the filing of charges. Now, the district attorney here also does not object to a personal recognizance bond. That will be a $3,500 personal recognizance bond. If you don't appear, you will not have another PR bond. You understand?
Understood.
All right. We'll see you on July 14 at 1:30.
Okay.
Thank you. All right. Now we are ready to start those arguments. We've cleared the hearing room as much as we can. I've got folks here on DeMarcus Marquez. Is the public defender ready to go on the Marquez case?
Good morning, Your Honor.
Good morning. Mr. Marquez, have you talked to a public defender?
I talked
Oh,
to
there's
Mr.
Ms. Burrito, right on cue. All right, Mr. Marquez, let's give you a case number, 25 CR 1909. And I'll give you a court date as well. That's going to be in Division R2 on July 14 at 1:30 for the filing of charges. Now, regarding bond.
Yes, Your Honor. So I'm not sure if I am sure actually. The court obviously had a chance to review the affidavit. And I think that some of the charges listed are not supported by probable cause in the affidavit. Particularly, it does not sound, per the affidavit, like anyone was injured physically, let alone killed. So I would ask that the court not find probable cause on that charge. And I would ask that the court set a personal recognizance bond or a bond set significantly below schedule. Mr. Marquez's total CPAT score is 13 points. He's a category 1. He's very young, but he has no criminal history whatsoever. He lives with his mom. He's lived here his entire life. He recently graduated from high school and is now working as a welder.
And
all right. Let me go ahead and hear from Mr. Hoisington.
Thank you, Your Honor. I did receive a message from intake that there is a typo in the affidavit. The top charge should be a class 3 felony, attempted second-degree murder, attempted murder, not the class 2 felony of murder in the second degree. I would ask for bond to be set at schedule, given the serious nature of these charges involving a weapon, noting he doesn't have any criminal history, but due to the nature of the charges and the allegations contained in the affidavit, I do believe a cash surety bond is appropriate.
And are you asking for a protection order for whom?
Did you say for whom?
Yes, we've got, I've got a list of 13 alleged victims. I wasn't sure whether your intake had narrowed it down a little bit.
I could just have one brief moment to look to see if they did not narrow it down, but I can. Our request would be, go ahead.
Well, what I was going to say is in reading the affidavit this morning, yes, the omission of the actual act of killing somebody was missing. But what I did see is the prime example of extreme indifference, attempted murder here, shooting in a group of people. So I think there's a little bit of a disconnect on the attempted second degree. For 13 named victims.
Yes, Your Honor, I would.
And the affidavit, frankly, is a little lacking on 13 victims as well.
I would request mandatory protection orders for victim Amanda Aragon and Antonio Cisneros. However, I believe that the assigned DA on the case, if we could just reserve that issue of the mandatory protection order for the next court date, and if there's anybody additional based on their review, further in-depth review and viewing of the evidence, that we can maybe address that at the next court date.
So I remember.
Well, Mr. Marquez, in light of the serious allegations and aggravated facts presented by the affidavit, I think a bond set at $25,000 to absolutely be appropriate here. That will be the court's bond setting, $25,000 cash or surety. In addition, the court will issue protection orders for the named victims, Amanda Aragon, common spelling, date of birth 11/16/1989, and Antonio Cisneros, common spelling, date of birth 5/31/2011. These protection orders are not governed under Brady. They check boxes 1, 2, 3, 4, box 7, and 8B. No contact, no communication with the named victims whatsoever. No possession, purchasing, or controlling any firearms, weapons of any kind. Alcohol and controlled substances are also off limits. I will place you on the supervised release program with monitored sobriety to ensure compliance. These conditions are all the conditions of your bail bond. Thank you.
Right back here. Right there.
And Your Honor, can I just get that court date one more time?
July 14 at 1:30 for the filing of charges.
Okie dokie. Let's try Louisiana again. Let's see if we can get a victory.
Good morning, and we're in Baton Rouge, and the three of us will be conducting this hearing. You can see from our name tags who we are, and we've had several hearings already, and we'll continue. This is our second one at Rayburn, and we're going to continue the same way that we are. You are Mr. Jesse Shelton, is that correct?
Yes, sir.
What is your DOC number?
574125.
Okay. What we're going to do, Mr. Shelton, we're going to hear in just a minute what you got to say about why you're there and what you've done since you've been there and why we should give you a chance to get out early. And then we're going to ask the warden what kind of fellow you are. Then we'll immediately go into talking to three folks that are behind you, Michelle Shelton, Carl Shelton, and Shannon Burris. And so that's the way that we will conduct this hearing this morning. Then Ms. Ledoux and Mr. Tillis and myself will ask you questions, and then we'll vote. Pretty simple. So the first step of it is for you to tell us why you're there, what you did, what's changed in your life, and that sort of thing. Tell us, convince us something.
The first part of the question was why I'm here.
I'll let you answer whichever part you want. I was just giving that as an example.
All right.
Tell us about yourself.
Well, I've been at Rayburn here and in prison for 15 years. As soon as I got here, I seen that I had a lot of time. I wanted to pursue what I could. And at that time, what was available was academics. And so I probably got a little aggressive with my education, but I dove into it. I acquired 4 college degrees and helped 300 inmates get their diplomas as a tutor and entered every kind of program I could find. And I was new to prison, so it was difficult. And I just wanted to keep my mind busy and stay focused on my future rather than what was going on in prison. It was easy to get caught up in prison. I could see that. And I didn't want to fall into depression and all the difficulties of prison. And so I made academics my pursuit. We had a fantastic lady here, Deborah Cook, who headed up that department and really gave us some alternatives. And I spent most of my 15 years helping other men do the same. This has been my pursuit. Right now, I am currently working for HVAC. I went through my academic years, my first 8 years, then I pursued vocation for several years and got 3 certifications in automotive. I got a business degree. That was one of my 4 college degrees. And I got a business degree in the academics and a couple of religious degrees. But I pursued, like at this time, my academics were behind me. So I pursued the vocation that became available as my time got shorter. And so I followed that with my last 4, maybe 5 years. I've been working for HVAC, taking what I learned in building technology and just preparing myself for my future, my jobs when I come home.
Okay.
But I mean, there's more. I've been here 15 years, so there's a lot. That's the condensed version.
Move on to the crime itself.
Okay.
Tell us about the crime and what you did wrong and what you do differently.
All right. All All right, my crime is aggravated incest, and this occurred in 03 when well, around that time, and it was not a very bright chapter in my life. I was going through difficulties, and unfortunately, I want to be careful how I say what I say, but I want to be honest. I committed a sexual crime with my own daughter, and went through a lot of denial and didn't want to face up to it. I tried to, but I have to say now, as I look back, I tried to do that my way, and it didn't work out well. I had a lot of help during these 15 years here. Outside ministers coming in, and just I really was amazed at people that could help me with my struggles and face the facts and get me to see the real damage. One of the results that came from me confronting myself and issues from my own past and acknowledging how that really affected my daughter, the victim in this crime. I pursued here what we have a victim awareness class, and that tool, trying to work with others who have done this and deal with my own issues, made me really, Mr. Prater, made me look deeper into who I am and why these things happen. And fortunately, there's a lot of good programs here. Men will take advantage of them, but you got to want. And I think my want to got changed. And by God's help, I psychologically, you can't fix yourself. And I know that I've done everything in my power to do what I could do, and then had to realize that would never be enough. Then outside help, like I said, came in and brought to me freshness and said, listen, you need to work on this. You need to work on that. And I put behind me what I had behind. And the last hearing, it was amazing. I guess I didn't know how badly I needed forgiveness, but I was told you can't pursue that. You can't pursue getting forgiveness from your victim. That's inappropriate. And I agree. But when she offered forgiveness in that last hearing, and even Mr. Roche read a part of that, it opened a whole new chapter. These last 3 years since that last meeting, it's really helped me see a future I can own. You can plan for it and want it, and it's all sounds great, but if it's not personal, real, and the release I've gotten, I'm free. I hope this board can let me go in good conscience, your good conscience, and begin the next chapter of my life. But I wasn't ready until I put those things behind me. In these past 3 years, I've spent really delving in. I don't know how to pick. I'm lost for words, but I'm grateful. I'm shocked really at the potential I still have. I guess I threw myself, my hopes away when I came to prison in some aspect. And it's not about me, but if I'm going to go out and be who I am going to be, I need to be a father. I need to be a husband. I need to be a man of integrity and have some stability in my life. And I believe because I dealt with the things the last 3 years, that I'm more equipped to do that. And I guess that's how I have wrapped that part up.
All right, thank you. Warden, what kind of fella has he been?
So he's been here since 2011 with only 6 disciplinary issues. The last one's been in 2017. He is working in our maintenance department here with the HVAC. And most every time I go into the church and religious services, he's in there in some way, shape, or form.
Okay. All right. Thank you, sir. We appreciate that we'll go ahead and hear from, the three folks that are behind you. Whichever one wants to speak, if you would keep it to around 2 or 3 minutes, we'd appreciate that.
Hi, I'm Michelle Shelton. I'm Jesse's wife. I'm here speaking on his behalf. We've been together since we were 16 years old. If there's anyone who's been there, who knows him, it's me. And we've been through some horrific things in our life. We grew up together, still growing up together. But the main thing I wanted to say today is that I've seen so much progress in Jesse. There are a lot of things I believe that we still need to face in counseling that just can't be done. With the separation that we have here. I know I'm looking to seek some counseling together and individually in the future. And I'm here to say that I'll be the one who will make sure that he has a place to live, transportation, to and from obligations he may have should he be released. Seek that counseling and working together toward proper healing. It's very difficult with a proper healing process when you're separated. And so I'm asking that you would consider giving him that opportunity.
Okay.
Yes?
You're his wife?
Yes.
Your kids, you have kids together?
Yes, sir.
Okay. Thank you.
All right, thank you, ma'am. We appreciate that. We'll move on now to, let's see, who would like to speak next? Carl? Okay. Carl Shelton.
I'm Carl Shelton. I'm his older brother, and I've known him all my life, and I'm here for support. So if he does get out, he needs talk or help, I'm here available for him. You know, I've been seeing him all throughout the years and seeing his progress. I really don't know the deep details because I didn't want to get into it, but I'm here for moral support to better the life, better his life.
Okay.
Things
All right.
heal.
Thank you, sir. We appreciate you being here and thank you for your words. We'll take them into consideration. Mr. Shannon Burris, Pastor Burris.
Burns, B-U-R-N-S, sir.
Oh, okay. I'm sorry.
Burns.
Burns.
Burris.
B-U-R-N-S?
B-U-R-N-S, yes, sir. Burns.
Okay, Pastor, tell us what's on your mind.
Okay, I've known Jesse since he and Michelle were young married people with babies. And I just want to say that Jesse committed a crime that was reprehensible, and he recognizes that. And but that wasn't the totality of the Jesse Shelton I knew. He was also a fine man in many ways. He was a benefit to our church and our community, and we're sorry that he did what he did, but he's paid a high price for that already. He's paid a pretty heavy debt, and the God that I serve is a God of judgment as well as mercy, and he has mercy in with his judgment. So I don't believe holding Jesse a lot more years would actually make a big difference in his recovery. In other words, if he hadn't responded now, I don't know that he would if you hold him a lot more years. I just feel like I'd love to see him have a chance to prove himself again in the community.
Should Mr. Shelton be released, what would you allow him to do in terms of your church? Any activities?
he wouldn't be allowed, as far as our church is concerned, he wouldn't be allowed to have any authoritative responsibilities at all.
Thank you.
Yes, ma'am.
Anything else? Okay, thank you, sir. We appreciate that very much. And now it's time for us to ask any questions that we have. And Mr. Shelton, I don't want to. We handle a lot of these cases. We get tired of reading them, and we get tired of talking about them. And I know in this case with aggravated incest, we don't necessarily want to go over everything that occurred, but it's a horrible crime. At one time, you said it wasn't sexual. Was this a sexual crime?
The nature of the crime is titled sexual. So when I say sexual, yes, that's it. With my reservations in the past, and I have sorted through these past 3 years. I really have, because I know I need to answer this. Yes, it was sexual. My defenses in the past, I have to give those up, were based on, well, I didn't intend to do it. My intentions. Well, that doesn't change a hill of beans about the consequences. They still fall out the same. She's still traumatized regardless of whatever you want to say about what your motives were. And when I communicated that, of course, it's going to go like it sounded, just like it sounded. And I go, well, you can have these reservations, but you better understand the rest of the story. And that is, I can't in good conscience say it wasn't a sex crime at all. I mean, I know you don't want to go into the details, and I thank you for sparing me that. But it's like, yes, it was definitely sexual in nature. If if a third party, a date of hers had done what I would be on that in a way that would not be good. But, you know, it took a while for me to see that. So I know the first 2 hearings, I was still saying the same thing. And I'd have to just change my viewpoint on how to communicate this, not just to say the right words so you hear them. Man, I have to dig down and find out what was I really doing. And that's what I was doing. I wasn't trying to belittle the crime. I was just failing to see.
Okay. And you pled guilty to aggravated incest, is that correct?
Yes, sir.
Okay. All right. That's all the questions I have. Mr. Ledoux?
I'd like to go into executive session.
Okay, we have a motion to go into executive session. Do we have a vote on that, please? We need a second first.
I'll second that.
Got a motion and a second.
Ledoux? Yes.
Yes.
Yes. Okay, we're gonna go into executive session for just a moment to discuss some procedural matters, and then we're going to come back and let you know what our vote is. All right?
Thank you.
So I think I understand perhaps what he was trying to say, but he certainly wasn't saying it well, and I'm not sure anything he would say would necessarily help him. But yeah, I don't think, at the very least, I don't think it was articulated very well. So let's go spend a moment with Judge Mogan, and we'll come back to that and get a conclusion here shortly.
We will go on the record in the matter 25 CF42, State of Wisconsin versus Stephanie Achterling. The state appears through District Attorney Kevin Schmidt in person. Ms. Achterling appears by video conferencing in custody in Burnett County Jail. We have Shirlene Parent, her counsel, appearing by video conferencing capability. We're set today in this matter for a bail bond hearing. Ms. Parent, I believe you have requested to be heard on bail modification, and you filed a motion. What would you like to state and argue on the record?
Yes, Your Honor. I filed a bond motion because Ms. Achterling was accepted into treatment and she would like to be released into treatment. So she would ask for a signature bond. There's a bed available to her. They will pick her up, bring her straight to treatment. The bond could say that if she were released for treatment, she would have to go directly back to the jail for another hearing, for another bond hearing. So we request that she be released under those conditions.
Mr. Schmidt?
I would oppose modifying bond, primarily based upon the seriousness of the charges. There's a great penalty with these charges and what's been alleged. And the court can also consider the strength of evidence because a person measures their likelihood of appearing in the future based upon the certainty that they will be convicted as well as the possible penalty. This is a case where 4 homes were burglarized. The property from all 4 were found in the residence, in the room that she shared with one of her co-defendants. One of her relatives had more of the stolen property that they said her boyfriend, Robert English, brought over. There are text messages between her, Kenneth Ochterling, and Robert English about the burglaries and disposition of the property. The criminal complaint says that her DNA was found inside one of the places burglarized, one of the 4 that was found mixed in with her property. We've now gotten DNA back matching, putting her DNA in a second one of the homes. So her DNA is in 2 of the burglary victims' homes. The court's probably noticed there weren't any drug charges. I appreciate she's trying to do something about what she's dealing with treatment. I don't know that it even has a nexus to these charges. I didn't know she had a substance abuse problem. We didn't see that in her messages. We did see it in Robert English's messages. So I could see some connection there. But regardless, the main reason for the bond, I think the court has this likelihood of non-appearance based upon very high amount of evidence, that DNA to 2 of the burglaries and the high penalties. Thank you.
Thank you. What treatment facility is it?
It is a adult teen challenge. Your Honor, I would also note she doesn't have prior criminal history to speak of.
All right, thank you. Well, the Adult Teen Challenge is a very lengthy program. It could be up to a year or a year and a half long. These are very serious cases involving serious crimes. Mr. Schmidt has presented to the court that there is significant evidence pointing to some involvement by Ms. Achterling in at least 2 of the alleged burglaries and criminal damages to property. I've said it before, treatment is not a get out of jail free card. And that's what a lot of inmates would like to use and try and say, well, I need to go to treatment now. Can I get out of jail? I'm going to look at going to treatment now because I'm in jail. It isn't a get out of jail free card. And it must be looked at with high scrutiny when people ask to be released from custody in order to attend a treatment facility. As Mr. Schmidt did indicate and point out in this criminal complaint, there is not a nexus or a connection between Ms. Achterling and the crimes and any alleged substance abuse disorders. So based on that, I am denying the motion to modify. So we need, where are we looking at going now, Ms. Perrin?
I would ask for another status conference.
Can you do August 18th? Or do you want me to put it on your week, Mr. Schmidt?
My week, please.
Can you do August 14th? Is that too soon? That's giving you about a month.
That would work for me.
All right, August 14th. I could do 9 o'clock or a 10 o'clock or 11:15. Oops, I lost Ms. Perrin. Well, I'm gonna schedule it then for 11:15. 11:15 on August 14th. That doesn't work, she can call Mary and get it changed. All right. All right, thank you. We are adjourned.
All right, let's go back to Louisiana and get the conclusion of that hearing.
Well, first, and my vote is to deny your parole request. I don't think I think we need to go ahead and, in my opinion, serve out the rest of your time. You've done great while you're there, but we still have the issue of the fact that it was such a horrible crime, in my estimation, aggravated incest. So my vote is to deny.
My vote also is to deny.
My vote is to grant parole with some strenuous conditions. Your release would be in 2029. That gives the probation and parole officers time to review your conduct and watch you closely. But you needed a unanimous vote today.
Okay, I'm sorry to tell you this, but your parole request has been denied. The time is 9:47 in the morning.
Denied.
There we go. For whatever reason, my mic didn't want to turn on. Not surprising. Not surprising at all. Let's go spend a few minutes with Judge Boyd.
Were you retained?
I was retained, Judge. They did make an offer. Obviously, they were kind enough to keep it open for 30 days, and that's kind of
All right,
where we're
let's
at.
do this first.
Yes, ma'am.
We're going to go on the record in 2025 CR 006031, 2025 CR 007000, 2025 CR 007003, and 2025 CR 007063, State versus Troy Xavier Trevino. Are you Troy Xavier Trevino?
Yes, ma'am.
Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Troy Xavier Trevino.
All right, your previous attorney was John Pettis Jr. He filed motions in each one of your causes to withdraw as attorney of record. Do you have any objection to his withdrawal?
Okay.
All right, so in each cause number, the court will grant the defense's motion to be withdrawn as attorney. And your counsel currently is?
Travis Kettner, Judge.
All right. And do you have an objection to this being your attorney? All right, we can go off the record. So where are we now?
Judge, they made an offer this morning, and they said they would keep it open for 30 days. And that's kind of where we're at. So I'm pretty familiar with what's going on. I've been talking to his family and stuff, but obviously we need to get the electronic discovery. I'll talk to him next week. So we're in good shape.
All right, Ms. Ferguson, if you can set this, please, for a plea deadline date in 30 days.
I think August 11th.
That should be good.
All right, August 11th would be your plea deadline date.
9 a.m.
Yes.
Thank you, ma'am.
Thank you.
Sweet.
On your progress. 24. 1737.
Mariano Rendon. right. Oh, this is Mariano Rendon Jr.
Yes, Judge, I've filed notice of appearance as additional counsel. Mr. Bloomquist is aware. He was anxious to accept the plea agreement as the state had offered him. Larry's in trial in Comal. And so I'm just here to, well, I'm new on the case, but we want to delay the process with doing the substitution. So he just let me do the additional counsel notice.
So in the indictment, it has him down as Mariano Rendon, but then in all the plea paperwork, it says Mariano Rendon Jr. Is he a junior?
Yes.
Okay. All right, the court is calling 2024 CR 2339B, State versus Mariano Rendon Diaz. I'm sorry, Mariano Diaz Rendon Jr. Do I have parties announced?
Raymond Martinez for Mr. Rendon.
And are you Mr. Rendon?
Yes, Your Honor.
All right, have you had a chance to meet with Mr. Martinez?
Yes, Your Honor.
Do you have any objections to his standing in for counsel?
No, Your Honor.
And Mr. Martinez, did you speak with his counsel?
A couple of times, Judge, and earlier this week, I explained to him he would be set today. And he related, he didn't know when he could come in and do the plea because he's in trial in Comal and he may go into next week.
All right. Counsel, have you received all discovery?
We have, Judge.
Court will find that the state is in compliance with discovery. Mr. Rendon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Rendon, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
All right, off the record for a moment. So he was sentenced in another case, correct?
Right.
So,
Same incident, different charge.
all right, so in that case, he received prison time?
Yes,
So he wants to be in prison, then come out on deferred?
that's the offer the state's making. He wants to close out his case. He doesn't want to stay here waiting to try another case. This is the same offer the co-defendants have received. He's okay with it. He wants to go serve his time and then he's willing to do the probation.
So how much time did he do, how much time did he receive on the other case?
3 years.
3 years? So do y'all want him to go to prison, then come back out and be on deferred?
I believe that is the state's intent.
Okay, all right. Okay, thank you. Did you review the, I'm sorry. Oh, we're still. All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with aggravated assault with a deadly weapon. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I give you all.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rendon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's an affirmative finding of deadly weapon. The state recommends deferred adjudication. There's to be no contact with the complaining witness, anger management, MRT, and TAP. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be 200 hours community service restitution. no contact with the complaining witness in a TAP evaluation. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments, Your Honor.
No objection, Your
All
Honor.
right, State, you may be excused. Did you review the waiving stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, right, just hold on a minute. All right, if we can go off the record for a moment.
Okay, the crowd has voted. We will go to Judge Simpson, but I'm going to wait until this is completed, so hopefully she's not off the record here for too long. But after this, we'll go spend a few minutes with Judge Simpson to finish out the day.
All right, who's here on Mario Vargas?
And we just aren't going to get an answer to that, are we? I'll circle back, as they say, and see if there's anything significant after the fact, and if there is, we maybe do a video or something on it. As promised, let's go finish our day with Judge Simpson.
So for purpose of the arraignment on that charge, I would waive formal reading and stay on mute.
Mr. Fonseca, you understand the nature of the charges in that case?
Yes, sir.
You understand the maximum penalties?
Yes.
And you do wish to be represented by counsel?
Yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. So in terms of setting the probable cause in this matter.
Well, Your Honor, this would be, I guess, now 2 felony matters. It looks like that would be pending.
This doesn't have to do a date. Okay. All right, go ahead.
We do have the bond violation as well. That was
Yes.
alleged. I guess obviously.
Which are different than the new charges.
Correct.
But
so, I mean, I guess if we just could keep everything together and have
Yes.
a couple of weeks, I think that would be satisfactory. I should be able to get a discovery request submitted today, and hopefully we'll have those materials prior to the next.
I'll
day.
adjourn then everything. I'll adjourn the one that's set for PCC as well as the bond violation hearing. I'll adjourn that to the 22nd, 2025 at 9 a.m. Bond will continue on that matter. On the other matter, I will set the probable cause conference for July 22nd, 2025, 9 a.m. His bond in that case his bond in the other one. So how many cases is he being held on right now?
It is just the bond violation, correct? Because you were out of custody, right?
Yes. Bond in this case will be set at a $5,000 cash surety at this juncture. I'll order standard conditions, including no assault, behavior, possession of any weapons, no possession or consumption of any alcohol, recreational marijuana, or any illegal drugs. I will order that if the defendant is released, he is to report over to community corrections for 2 times per week drug testing.
Thank you, Judge. Your Honor, on the matter pending with the bond violation, was bond revoked?
It was.
Okay. Thank you, Judge.
So his bond will be revoked on that matter. Correct.
Okay, what time do I go back?
I'll be over to see you.
Pardon? Court calls the case People versus Antonio Williams.
You took the people? Brian Boley on behalf of Mr. Williams. Oh, he's on the screen. Your Honor.
Mr. Williams, do you have somebody that can unmute? So you can tell us, can you unmute the device?
Judge, he can hear you, but he's basically blind. So
okay.
He won't be able to, move around within that room to.
All right, Mr. Williams, if you can hear me, if you can wave your hand so that I know that you can hear me. All right, thank you, sir. What do you want?
Judge, after meeting with Mr. Williams at the jail, I believe that a competency examination is appropriate in this matter, so there should be a proposed order in the court's file for that. I'd ask you to sign it.
All right, I will sign those orders for a forensic evaluation ordered. I'll set a competency hearing for 90, please.
October 9th,
October 9th, 2025, 9 a.m. Bond on this matter will continue.
Thank you, Judge.
Court does call the case People versus LaShawn Charles.
And Lori Yagi, Assistant Public Defender, with and on behalf of Ms. Charles. Ms. Charles, can you state your name for the court?
LaShawn Charles.
Got her.
Thank you. Your Honor, we're asking for an adjournment for further discovery in this matter.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Have a good day.
You do the same. Court calls the case People versus Darrell Frederick.
Assistant Public Defender Jay Bellinger on behalf of Mr. Frederick, who approaches.
Ms. Wyman.
Mr. Frederick, can you please state your name for the record?
Yeah, Frederick. Go ahead.
And Your Honor, we've signed a waiver and I got my client's permission to sign that on his behalf.
Oh, sure have. All right. So you're waiving your right to a preliminary examination?
That's correct.
All right, you understand that's a proceeding where people would have
To whatever you were talking.
understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
That's correct.
And you understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
That's correct, Your Honor.
All right. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of information. We have formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 22nd, 2025.
July 22nd, 2025, 1:30, Judge Conklin.
We'll be in touch, okay? Thank you, Your Honor.
Thank you. Bond continue. Court calls the case, People versus Bradley Chavez.
On behalf of Mr. Chavez, can you state your name for the record, sir?
Bradley Chavez. All right.
We are going to be asking for a brief adjournment so we can continue plea negotiations with prosecution.
Probable cause conference, July 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond continue. Court calls the case, People versus Robert Gallet.
Kerma Dadush on behalf of Miss Gallet on the case ending in 713.
Morning, Roger Kilwell, Judge. I'm on case 5612.
All right.
Your Honor, we were going to be asking for adjournment in our case and a chance to address bond, please.
You're also asking for an adjournment?
Yes, I'm sorry.
All right. Go ahead and address bond.
Thank you, Your Honor. First of all, Miss Gallet here wanted to apologize for missing her last court hearing. Since the start of this case and since her last court date, a lot of things have changed. Miss Gallet has, first of all, now she has a phone number, a phone that we can contact her on. She has gone back on her medications. She has bipolar medications that she has to take, as well as hormones. So all of that kind of, well, it can, not, I don't want, let me word this correctly. All of that is helping us reassure, we're using that to help reassure Your Honor that she is going to show up if she is released on her own personal recognizance. She has also, she has two different caseworkers helping her. She has a CMH caseworker and a PATH caseworker. She has been approved for Avalon Housing if she were to be released. So all of that combined, her having a more secure home, having a phone number and medications. We are hoping to get a personal recognizance for that reason. She will appear. She has no intent, and there is nothing else holding her. I believe she has a 15th district court case, but that she has a PR for that.
How did she come back in custody?
On the 15th case, Your Honor, 15th district court case, which is just a Parks violation.
When did that happen?
I believe on the 4th or the 3rd, July 3rd. Well, that was the day.
So between March 20th and that time, what was she doing?
She was, let me talk. She was unmedicated. Her husband he also has bipolar and schizophrenia. They were both unmedicated. They were both homeless, doing quite poorly. Since then, all of that has changed. Her husband is in custody, but she is really trying to do her best. She, picks up debris with the Parks and Recreation program, Give 365. Again, her meds are a very big part of her ability to, come back to court and be more stable, have stable housing. And she hopes to even start classes with Washington Community College wants to do linguistics, just wants to start becoming better, and her meds was the first step to that, Your Honor.
Mr. Killowald, anything?
I would just echo that argument, Your Honor.
Anything from the people? I really don't necessarily need it, but go ahead.
Two sets of concerns. I appreciate that it sounds like there's some progress being made. That case in the 15th district is an assault matter at Gilbert Hospital. I understand that things have happened in the psychiatric environment there, but that event is just June 28th. And I'm concerned about some of the behaviors there and wondering, it sounds like there's been a very dramatic turnaround within a very short amount of time. I don't know if Mr. Gooch has anything to provide proofs of some of the housing. This family is apparently a native of the California area, doesn't really have any ties to our county either. So I'm not sure. I'm not sure that we'll see her, quite frankly. If we do have.
So when I say I don't need it, what does that mean to you?
Well,
go ahead. No, go ahead. I'm listening.
I had options. You told me you add.
No, I did.
Although you don't need it. So, that's okay.
Thank you. Motion for bond reductions denied. Bond will continue. I'll set the probable cause conference for July 22nd, 2025, 9 a.m. in both cases. Thank you. Court calls the case, People versus Deshaun Clifton.
Stephanie Cannon on behalf of Mr. Middleton.
Oh, boy. Oh, boy.
And Your Honor, we're simply asking for an adjournment. I'm sorry.
She did? She said her name?
I did.
I didn't hear it.
Oh, you want me to do it again, Your Honor?
No, really not.
Okay. Mitigation information has been provided very recently to the prosecutor in this case. We're just asking for some time, 2 weeks, Your Honor, for her to review it and see if an offer is forthcoming.
Will the 22nd work?
It will, Your Honor.
The 31st, all right. Probable cause conference, July 22nd, 2025, 9 a.m. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, sir. Court calls the case, People versus Haruska Dennis.
And I'm acting on behalf of Mr. Haruska Dennis, who is approaching.
Again, Your Honor, Christina Costantino appearing on behalf of Mr. Haruska Dennis in the case number ending in 5076.
Oh. All right. Your name, sir?
Zachariah Haruska Dennis.
Thank you.
We're respectfully requesting an adjournment in this matter. AIM sent over a mitigation report last night, and the prosecution needs time to review it.
And I would join in that request.
All right. Will the 22nd work? I think that's what we set your last case, Ms. Constantino. Is that right?
Yes, Judge, I would ask for the 22nd, given he is in custody.
Probable cause conference will be adjourned July 22nd, 2025, 9 a.m. Bond will continue. And Ms. Constantino, I will tell you, I miss you too. And Mr. Allen told me I wasn't very nice in saying what I said the last time. So I don't know what's going on there, but he was kind of yelling at me.
Well, thank you, Mr. Allen, and thank you, Judge. I appreciate you changing your mind. I hope to see you soon.
Yes, ma'am.
Thank you.
All right, folks, we should probably call it a day since we've gone a little bit past, and I should probably focus on some other things today as well. Interesting day. It started out with me on the pre-show kind of yelling at a microphone for a little while, and then got a few denials in Louisiana and some other good court. I hope you all had fun. I know I did. We'll be back tomorrow, which is Friday already, a week past the 4th of July already. I don't know how the time moves so fast, but it does. But we'll see you at 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Again, I encourage you, if you're not a channel member, become one. Join us on the pre-show. It's fun. I think people even had fun today with me kind of going a little crazy, which I don't normally do, but always something different. But yeah, we'll see you tomorrow. In the meantime, have yourselves a great Thursday. Take care. God bless.